crazy, right? Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Here, your first time business with the Appellate Division. Draw near to the attendance and you shall be heard. Please be seated. Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember that the panel, if we have additional questions past the time you've been allotted, we will ask them, and you'll have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Jonathan Alfonso. Submitted. Ilgout v. City of New York. How much time would you like, counsel? Would you like time in rebuttal? Counsel? Okay, 4 and 2 and 4. Esther L. v. Chaim L. Submitted. Wilmington Savings v. Brown. You want time in rebuttal? Sure, make it 3 and 1. 3 and 1 and 3. Thank you. Sorrano v. Athena Properties. Do you want 4 and 2 as well? Should we do 4 and 2 and 4 and 2? Okay, 4 and 2 and 4 and 2. People v. Baron Williams. 4 and 2 and 3. People v. Anthony White. Four and 2 and 4. The next two appeals are Fondela v. 345 West 70th Tenants. We'll take them together. You're here for Fondela, I take it. We're going to handle them both together. So how much time do you want conjoined? 18 minutes. Okay, counsel, how much time would you like? 5 minutes. Okay, we'll go with 6 and 2 and 6. Matter of Wells Fargo Bank could be HBK Master Fund. Okay, who are the respondents? Okay, we'll go with the two appellants, 5 and 2 and 5 and 2, and with the two respondents, 5 and 5. SL 400 Connecticut v. CBRE. Mr. Borgo, is that you? Can you hear us?
Yes, my apologies, Your Honor. I could not hear the time requested by appellants.
Counsel? 8 and 2, he asks.
6 will be fine for responding.
Okay, we'll go with 5 and 2 and 5. Thank you. De Perez v. Forom Valentine. 2 minutes. 4 and 2 and 2. People v. Gino Soio. Thank you. We'll go with 6 and 2 and 6. Falsao, I don't know if I'm pronouncing that correctly, versus MTA. Submitted. Falsao? Anybody here on Falsao? Falcao, v. MTA. Okay, submitted. People v. Christopher Harrison. Submitted. Mazero v. Broadway 52nd. For Broadway? Okay. Okay. We'll go with 5 and 2 and 5 and 2 and 4. Khan v. Khan. I don't think you have an opponent, Ms. Khan, so we'll give you 3 minutes. People v. Oliva. Give you 5 and 2 and 5. Gurney Goldman v. Solil Management is submitted. First case up is Ilgout v. City of New York. Please.
Your Honors, may it please the court. My name is Richard Washington, and I represent the petitioner appellant, Brian Ilgout. We're here because basically my client was removed from a position that he had served in provisionally for 3 years without issue, following an examination that was rendered by DCAS.
If you were to be granted relief, if the case was permitted to go on, what would happen to the other people who had been, what would happen to the other people who had been on the list? They haven't been brought into this case, have they?
They have not, Justice Friedman. And respectfully, I understand the court's concern with regard to that, but I think the dismissal of the petition at the Article 78 level was really premature. One of the things that the city noted in its opposition to our papers was that my client, Mr. Ilgout, didn't have a right to the position because there's still the 1 in 3 rule where they could pick him off of the list. The issue with whoever's on the list at this point, they would stay right where they are, because the only thing that would really happen is following passing the test, he would be placed on the eligible list if he were to get the extra 2.5 points. I think what would happen to them would depend on the other questions that are raised within the appeal as it relates to the examination itself. So we have a few different issues that we've raised on the appeal. The first one being the substance of the examination. The second one being whether or the substance of the scaling, right? Because you had this examination that was rendered for the senior civil service engineer position, but The Health and Hospitals Corporation, as it exists, their senior stationary engineers handle completely different
Just to
functions.
return to the first point, though, you're not disputing that Miles, who was the other SSE candidate who's mentioned in the complaint, and the other engineers, you're not saying that they're not subject to the jurisdiction of the court.
Absolutely not. But also, to your point, Justice Moulton, that would be one of the reasons why we had asked that if there was going to be an issue of joinder, they could have been joined. We would have no objection to them being joined. We didn't feel that that was
We
necessary.
don't know who they are.
I don't know who they are, Your Honor. Justice Chan, the only people that know is H&H. The lower court could have ordered H&H to provide us with that information, and we would have joined them and the case could have proceeded. My issue is that we had a meritorious claim. There is a way very easily to identify any interested party. They could have been added. We could have reached the merits of my client's claim, but we didn't do that. We just dismissed it summarily.
I interrupted you, though. You were about to talk about why the civil service exam was administered unlawfully.
Yes, Judge. The thing my point I was making was we have all these various different senior service stationary engineers that exist throughout the city of New York. Health and Hospitals is very different than Parks, is very different than the Department of Education, but I can speak specifically to Health and Hospitals, and the reason that it's different is because they're dealing with life-saving equipment, operating rooms, various other things that a person wouldn't encounter in Parks or in the Department of Education or any of the other places where that would be relevant. As I noted in my papers in the underlying appeal, I'm sorry, yes, Justice Chan.
Wouldn't a change in the exam, let's say, affect the other test takers?
That's a legitimate question. I have no idea because when the lower court stated that we're missing parties, are we missing only the people who tested for H&H under that exam, or are we including everyone that tested under the exam? We're challenging specifically H&H's examination and the fact that it didn't test the issues that it was noticed for. That's the biggest issue that we have. So I to the extent who it would impact, that's a question that I really can't answer. I think the bad faith component, if I may, the bad faith component is the bigger issue that H&H is aware that this does not test for specifically the duties and responsibilities of the position, but because they have a financial arrangement with DCAS, they are not willing to have DCAS formulate a different exam for them or to formulate an exam on their own.
But you didn't name, for example, as defendants, John Doe's as test takers, as placeholders until you found out their names, which would have at least established your intention to name those people and include them.
Justice Gesmer, it wasn't my intention to initially bring in everyone. When the appellant or when the respondents raised that issue, we responded that we didn't know who we'd be bringing in. We don't know. As a matter of fact, we don't even know if there are actually currently now at H&H senior stationary engineer positions that are still being held provisionally. My client is still sitting in
time
this.
rebuttal to expound
I'm
on
sorry.
that. Thank you. Please.
Good afternoon, Your Honors. Shane Magnetti for the respondents. At the threshold, petitioner concedes that the court had jurisdiction over these necessary parties, and he's no longer pursuing his argument that the court.
So it must often happen that a test taker who challenges the test doesn't know the names of all the other test takers who could be named. How is that normally dealt with?
I'm sorry, how is that?
How is that normally dealt with?
Well, the rule is that it is the candidate's burden, if they're seeking to annul the results of a civil service exam, to identify and join all necessary parties.
Right, as a practical matter, how does that happen?
So as a practical matter, I can think of two ways that it happens. If you were to go on Health and Hospitals website, there's an email address that you can reach out to with inquiries about civil service exam results. That's one way you might obtain that information. Another way is through your union representative. But in this case, there's no dispute that petitioner never even tried to ascertain that information. His argument on appeal is that the court erred by not granting him leave to identify and join those parties.
But
He never made that argument below.
As a practical matter, does the union representative provide that information to its members? It's going to provide all the people who took that test?
Well, I can tell you in other cases, like for example, in the Adler case we cite in our brief, one way the court suggested that a party could get this information is by their union representative. But again, there's no dispute that petitioner even tried to ascertain their identities here. And
Also, what about plaintiff's point that it was arbitrary and capricious for H&H to have DCAS administer the exam because the resulting exam did not test for healthcare-based competencies?
so this court has held that DCAS has broad discretion over testing methodology and can rationally test for underlying competency rather than for any agency-specific expertise. So if you look at the notice of exams here, there is substantial overlap that any SSE at any city agency must have.
But with regard to health and hospitals, as counsel pointed out, they would have jurisdiction over engineering issues related to operating rooms and things like that. Wouldn't that require a difference in the test?
Well, two points in response, Your Honor. So counsel made that argument just now, but there's nothing in the record that an SSE engineer at Health and Hospitals works on medical equipment. His argument is that the notice of exam stated that the exam should test for reporting requirements for certain medical agencies, and that part of the notice of exam was in what the job involves, not in a different section of the notice of exam that sets forth what the test actually will test for. And back to whether or not it would be prudent to test for those issues anyway, again, if you look at this court's opinions in Gallagher and in Alonge versus Carnival, these kinds of challenges to the specificity of the content of an exam, the court has rejected so long as the exam is designed pursuant to a valid job analysis, which petitioner does not dispute and which Health and Hospitals was actively involved in, and tests for the underlying competencies of the job. And here, an SSE at any city agency is required to operate, repair, and maintain any equipment that essentially allows the facility to function. Any SSE has to have those capabilities as to underlying principles of engineering. And that's what the exam tests for. And this court has upheld that practice in Gallagher and in Alonge, and it should do so again here. And if I could just hearken back to my first point very briefly, petitioner's argument that the court should have granted him leave to identify and join these parties is not preserved. He never asked the court for that relief below. When the city made its motion to dismiss, he did not even address the argument that all of these other parties were necessary. So the court cannot have abused its discretion for failing to grant relief he never asked for. Thank you.
May it please the court, just to address, if I may,
Once you start the action, is there anything that would have stopped you from coming to the trial judge and say, well, look, for this case to go on, we need these other parties. I want you to issue an order to defendants requiring them to disclose to me the other test takers.
I'm sorry, Your Honor.
Why couldn't you have asked Supreme Court to issue an order directing the defendants directing the defendant to provide you with the names of the other test takers?
Well, Justice Freeman, I believe that would have been an issue if we would have gotten to the point where we ruled the test invalid. If we had gotten to that, if we'd even reached that issue on the merits, that would have been something that could have been done. I just wanted to go back, if I may.
But you're suggesting that the mere fact of you're getting your client getting more points wouldn't affect the other test takers. But why doesn't that change things for everybody else?
It doesn't, because the eligible list, the people who are appointed to positions are already placed on that off of the eligibility list. The only thing that getting more points would have done is it would have placed him on the list. As I was going to say right before I sat down, I was saying to Justice Moulton and to you as well, Justice Gesmer, the reality of the situation is there are still vacant positions for SSE at H&H, and my client is still in one of those positions provisionally. There are plenty of provisional positions.
The score doesn't affect your place on the list?
I'm sorry?
The score doesn't affect your place on the list?
Absolutely it does, but we don't know how the score, that's part of the arbitrary argument that we're making. We don't know how the score was tabulated. He received 3 scores in 18 months. Unlike Adler, I know counsel pointed out Adler, unlike Adler, my client in this case exhausted every possible, available, potential administrative remedy. He went to challenge DCAS administration of the test with the Civil Service Commission. They said, hey, we don't have any authority over H&H, and they sent him to the Personnel Review Board for Health and Hospitals. He went to Health and Hospitals and challenged that, and they sent him back. They told him they don't have authority over DCAS, so there's literally no way that he can challenge this test. And as it relates to Gallagher, this case is completely different from Gallagher, because in Gallagher, you're talking about positions that are both going to be in the fire department. To your point that you asked Justice Gesmer, we're talking about one position that's not going to be just at DOE or at parks regulating swimming pools. We're talking about regulating operating rooms, regulating surgical procedures. And to the point that
That brought up in your papers?
that is brought up in my papers, and it's also in the
Was it
notice.
brought up below?
I'm sorry, Your Honor.
Was it brought up below?
Yes, absolutely. And it also to the point that counsel was making, it's not in the record, it's in the notice of examination. If these are not things that H&H feels or that the city feels are necessary, why would they put it in the notice of examination that they're giving to people who are going to take the civil service exam? Thank you, Your Honors.
Thank you, counsel. Thank you both. My understanding is that one of the parties in matter of SRL is here.
Good
Ma'am,
afternoon.
my understanding is you're not a lawyer, right?
No, I'm pro se.
And your
Mr.
opponent's
Forom,
not here.
sorry.
So generally, the convention is that we'll give you 3 minutes to address us and tell us whatever you think is important about your case.
Okay,
So you can start now.
okay.
When the white light goes on, because I don't think you heard the speech, that means you have 2 minutes left. You'll see it when it happens.
Okay.
Please.
My voice is a little hoarse, so please forgive me. There was a June hearing under Magistrate Mahoney. There was a June 2023 and a September 2023. And then there was a January, which was postponed from January 15th to January 29th, 2024. And I feel that he was just retiring at that point of time. We did not know that. Nobody on the case knew that, myself or the other party. And later on, I found out at the end of January he retired. And we had a virtual hearing that was postponed from January 15th to January 29th, which I feel the magistrates that took over after him probably had no idea of or did not listen to. And I actually made it available, and I paid for a court stenographer, and I believe it's part of the record, where Magistrate Mahoney was giving Mr. Lauber the ability to get a lawyer under an 18B only because there was going to be a change of circumstances, meaning if he would go to jail, then such a person gets an 18B lawyer, and he wasn't giving it to me when I asked him for one. And then later on, everything was dismissed. And in fact, when we came back and I brought a lawyer with me to the courtroom, Mr. Schreier, who was appointed as the 18B lawyer, actually represented him. And I felt that if people looked carefully at the January 24 virtual hearing court stenographer that I requested, it clearly says he was only giving him a lawyer because this was an 18B case and there was a willfulness on his part. And I established, I don't know how to say it, a prima facie case. And apparently the burden of proof was on me to begin with. And then afterwards it's on the defendant. And he clearly said that he willfully disobeyed. He ordered him to pay the entire arrears, which I'm just saying by heart, I'm not really sure. I have 2 minutes. At 23, I think 691 at the time of Magistrate Mahoney, I checked with a child support collection unit today, and as of today, it's 24,654.35. And the magistrates that end,
And generally on appeals, we're stuck with what was ever in front of the family court.
that's fine. 23,691 is just fine. And they said that he was paying on time, and the magistrates weren't understanding that I had created a support collection unit case many, many years ago in December 2020, I think, and they were collecting exactly the same as they were since then, which was done not a matter of voluntary or involuntary, but he hadn't done anything with the findings of fact from Magistrate Mahoney or anything that Magistrate Mahoney, the red light,
Just a thought.
told him to do. He hadn't done anything, and they were saying, well, it doesn't matter if you don't like the method. If he did it or if it was involuntarily, it was done on its own, it's still happening. And I'm telling you, it's not happening.
Thank you very much. We also have your brief
Yes.
and the record in the case. Thank you very much, ma'am.
That's it.
That's it. You're free to go.
Thank you. Have a good day.
You too. Wilmington Savings v. Brown.
I apologize. I can't see anything without these. Richard Zarco for defendant appellant Raquel Cook Brown. Good afternoon, Your Honors. If it please the court. The gravamen of this appeal addresses
You
two
read your
issues.
papers. Since they pled it as an RPAPL Article 15 case, isn't that enough?
Not if the facts read differently. The construction of the case should have been one for reformation, or you could even argue that it would be one for imposition of an equitable mortgage. However, regardless of the construction of the case, the statute of limitations expired no matter which form of the case the court accepts. And the Supreme Court error specifically was that it declared the property interest of the mortgagee as one for a term of years. So that's a possessory interest that the mortgagee doesn't have to make it for a finite period. Therefore, the court impermissibly extended the statute of limitations with respect to, even if it was construed as an Article 15. However, the statute of
Doesn't RPAPL 1501 sub 1 allow the cause of action to go forward as long as it's, you've got 5 more years on the relevant instrument?
that's if it's construed as a property interest for a term of years.
Right.
We're saying that it's not an interest for a term of years because that requires possession. That would require a finite period of time. And so then essentially what that would do is that would allow the mortgagee 25 years within the period of a 30-year payoff on a mortgage to bring an action to quiet title at any time. The fact of the matter is that the statute of limitations on an action to quiet title is 10 years from execution of the note, or in this case, that's what created the property interest. The property interest is a lien. It's a security interest to secure repayment on the debt.
Just to return to another issue, you do argue at some point, I think, that they don't have an interest in the property. Isn't the fact that Wesley signed the mortgage, isn't that enough?
But it's a tenancy by the entirety. So
So that's a contingent interest.
it's a contingent interest, but then the action should have been one to impose an equitable mortgage, which if that's the case, then that's 6 years also from the execution of the note. But as far as the Article 15 action is concerned, that cause of action or that statute of limitation begins to accrue upon the mortgagee developing or acquiring the property interest. And that would occur at the time of execution of the note and mortgage.
Anything you'd like to add?
Yes, that ultimately, regardless, this case was commenced in September of 2020. So whether it's an Article 15, that 10 years would have expired in January of 2018, 10 years after execution of the note and the mortgage by Wesley Brown.
You make that point in your brief. Thank you.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. Your Honors, I'll be very brief. I think my learned adversary's understanding of this matter is to read into our argument assertions that we have not made. We have not requested a reformation of the mortgage. And most of the cases that my learned adversary relies on are cases that would solely involve a reformation of the mortgage. And that is the threshold.
Doesn't he argue that the word reformation does appear in the complaint and the word subrogation does appear in the complaint? I mean, he makes that argument.
Well, Your Honor, I mean, respectfully, lots of words appear in the complaint. It's about what we petitioned this court by means of notice pleading and the relief that we requested. The relief that...
Yeah, I was
Yes.
just wondering about the argument that the reformation is required first before you get to the point of declaring the interest.
I think that is not the case here, rather explicitly. This is a different case than a case in which a mortgage is signed by the wrong party, or you have a lot of these reformation cases, you have a mortgage coming from Deutsche Bank, but it says Citibank and something has to be reformed. This is a case where all of the parties have signed almost all of the instruments. And at least one of the defendants and one of the move-ins here has signed this instrument. No reformation could possibly be sought from him. So, because there's no question that he signed all of the documents. Regarding the other party, we don't need to seek reformation because we have a signed note, which is a controlling instrument here. So, reformation is not something we asked for. It is a different animal altogether than a quiet title action. It is qualitatively different. There are different elements to both of those. And since we haven't sought reformation, I don't think we should be held to the statute of limitations for a reformation. I have nothing else, Your Honors, unless you have additional questions for me.
Thank you, counsel.
Thank you.
Your Honor, if I might on rebuttal, with regard to what was pled in the action, the language of the action, they can manipulate the language to fit within the pleading requirements for an Article 15, but the facts dictate that it's an action for reformation, or alternatively, it would be an action to impose an equitable mortgage. The fact of the matter is that, yes, the note, as alleged in the complaint, was signed by both parties, and the mortgage was signed by one of the mortgagors. The fact of the matter is that they still need to bring the appellant within the ambit of the mortgage. And the only way to do that is either A, to reform it to include her, or B, to impose an equitable mortgage on her property interests, both of which are 6-year statute of limitations from the time of the execution.
You make that point very well in your brief, counsel. Thank you.
Thank you, Your Honor.
Thank you both. Sorrano v. Athena Properties.
Good afternoon, Your Honors. Jillian Rosen for the Plaintiff Appellant. This appeal rests on 2 words, the video. I'm assuming this court saw the video. The video is irrefutable evidence of defendant's statutory violation of 240 subsection 1 and 241 subsection 6.
There are 3 people that are apart from the plaintiff in the video. Did any of them give affidavits about this case or provide any kind of evidence concerning the accident?
Well, no, I mean, there is...
Maybe idle curiosity on my part. I saw them in the video and I wondered what happened to him.
Well, Mr. Johnson submitted an affidavit. He didn't actually see Ms. Sorrano fall, but he saw her on the ground, and then he averred that no harnesses were ever given. There was no place to tie off. And then Mr. Matthews, who was actually seen in the video, puts in an affidavit trying to rehabilitate the defendant and say we preserved the ladder, but that was properly rejected by the trial court because it was submitted for the first time in reply. So we have plaintiff's testimony, which is corroborated by the video, but the video is irrefutable evidence of this statutory violation. You see plaintiff descending the ladder. I know you saw the video, but it's so compelling that she's descending the ladder, and the ladder...
In your brief, you call it a textbook case of Labor Law 247.
Yeah, I mean, I think that this video could be, shown in like a basic labor law CLE class. It's exemplary of what this court has consistently held, where a ladder shifts or moves or tips or buckles for no apparent reason. There's a presumption that it's insufficient. It fails in its core purpose of keeping plaintiff off the ground. And even though we need no other evidence but the video, just go to the videotape, like Warner Wolf would say in CBS, just go to the videotape. Even though we don't need any other evidence but the video, we have defendant's own admissions, which establishes the reversible error by the trial court and the propriety of summary judgment to the plaintiff, because what does the defendant say? The defendant admits the following. This is Mr. Matthews. Ladder is unsecured in any manner, 114 of the record. Nobody's holding the ladder, 114 of the record. The ladder is not tied off at the top or the bottom. Plaintiff isn't wearing a harness. And even if she was, there's no place to tie off. So this is a completely unsecured ladder. No other safety devices are provided to the plaintiff. What the trial court should have done, it ignored Daniello from this court, in addition to the Begonia case, which both state that the plaintiff does not have to establish a ladder is defective in any way, but that's what the plaintiff, the trial court relies on that in denying summary judgment to the plaintiff. The court should have granted summary judgment to the plaintiff, found that they met their burden, shifted to the defendant. There's no evidence of recalcitrance or sole proximate cause. It should have granted plaintiff summary judgment on 240. The video is all this court needs to reverse.
And on top of all of that, she was an apprentice, correct?
That's correct. And her foreman set up the ladder.
That's Mr. Brown.
That's right, Julius Brown. I really think it's just, as I say, the video. I could take up 241, 6, and 200 on my reply, unless you have further questions. Thank you.
Counsel. Thank you for invoking Warner Wolf, that famous legal authority.
I wasn't sure. I wasn't going to actually say Warner Wolf because I wasn't sure if
No, you can tell the age of the people in the room by who got that and who did not.
It's revealing my age, which of course I didn't want to do, but now you know that I know Warner Wolf. And before he started any sports segment, he didn't have to say anything. He just said, let's go to the videotape, which is what this case is.
Thank you. Please. Yeah, you need to stand by the microphone, though. Thank you so much. Counsel, you have a cross appeal, so you have some time on rebuttal as well. So.
Yes, thank you.
So why shouldn't we just go to the video? Let's start there.
So the crux of our case is whether there are triable issues of fact as to sole proximate cause.
The microphone closer to you.
Sorry. And we're premising our argument on 2 points. Whether whether the ladder was improperly positioned, and if this improper positioning caused plaintiff to lose her balance.
Counsel, isn't it conceded that Mr. Brown positioned the ladder in the first place? You're faulting her for not repositioning it, right, after he positioned it?
Although Mr. Brown did set up the ladder, there isn't any case law saying that there isn't a case law saying that's an absolute directive, and she couldn't have.
Well, regardless of the position of the ladder, had she been provided with an additional safety device, such as a harness, she wouldn't have fallen.
Our expert, Angela Levitin, opined that there would not need to be an additional safety device. This was
Our expert who didn't see the ladder until at least a year later, as I recall.
So we believe that our argument, or Ms. Levitan's opinion, was sufficiently based on her inspection of the site.
Why didn't she need a harness?
It was a fairly standard A-frame ladder.
What about someone just holding the ladder?
Well,
Looking at the video, if somebody was holding the ladder, it seems like that would have been sufficient to prevent the fall.
Respectfully, a person isn't an adequate safety device under the labor law. And as I said, the A-frame ladder is a pretty straightforward device, known for its mobility as well. So I believe that supports that the ladder could have been repositioned.
Are you saying that an A-frame ladder doesn't give rise to a 241 action?
Absolutely not. But in this case, we believe that the improper positioning of the ladder caused the ladder to wobble, but it did not just merely fall for no apparent reason.
So the improper positioning might be comparative negligence. That still doesn't get you out of the 241.
Well, if this is comparative negligence, then it leads to our point that there are triable issues of fact, and it should go to a fact finder. That's our, if anything, our focus more is that there are triable issues of fact in this case as to whether she was the sole proximate cause of her accident.
Thank you, Counsel. You have time in rebuttal.
Okay, thank you.
Three things. First, on sole proximate cause, we know that plaintiff can't be the sole proximate cause when there's a statutory violation, and here there's a flagrant statutory violation. But with regard to this improper positioning, I think it's completely a red herring, because she didn't fall while she was securing the screw. She fell while she was descending a ladder. So what does that have to do with the position of the ladder? And she did testify that it was a tight, small space, which actually just reaffirms the fact that the foreman who positioned the ladder positioned it incorrectly. Certainly isn't on the plaintiff, but this isn't about the positioning of the ladder and how she was working. She was descending the ladder when it buckled and collapsed, so it is a red herring. The trial court properly didn't disregard Ms. Levitin's affidavit, but definitely found it to be speculative and didn't find it to raise an issue of fact. I don't want to belabor the affirmation. It is flawed in so many ways, but specifically because she inspected the ladder 14 months later. There's no evidence that it was in the same condition and it was in the same ladder because of Matthias's affidavit. But what's interesting about Ms. Levitin's affidavit is that she disregards the fact that the ladder was unsecured, and she talks about plaintiff reaching and leaning. Again, she fell when she was descending, and there's no evidence in the record that she was leaning, reaching. This had anything to do with why she fell.
Put the tool that she's using down. You can see her hold the top of the ladder with one hand. We saw that.
Yes, okay, so the evidence, the video speaks for itself, which I've said. With regard, I just want to touch base quickly on, I think it's academic, 241.6 and 200. I mean, the defendant was denied summary judgment. I just would say with regard to those sections that the textual elements were not made out on 241.6, and the video shows that the spreaders, it's the actual section that they sought to dismiss was 1.21b8, and obviously Ms. Levitin's speculative opinion that it was in good working condition is belied by the video. In addition, on 200, this is defective condition, and our position is the defendant admittedly owned the ladder. If they own the ladder, he was in the video, he knew it was unsecured, then he didn't take action to remedy a known condition. That actually should be summary judgment to plaintiff under 200. If you have no further questions, I'll rest on my brief.
Thank you, counsel.
Thank you.
So I just want to touch upon, despite her falling on her descent, we believe that it can't be viewed in isolation that she was descending. There are various aspects before the fall that...
What before her descending would be relevant to the ladder falling over while she was descending?
So her right hand was actually on the ductwork, and then her left hand was holding the drill and then resting on the top of the ladder. And she had to rotate her body to descend. So looking at the dynamics of her fall holistically, that contortion of her body caused the lateral forces and
Or maybe
resulted
the
in her
ladder caused her to twist her body?
Sorry?
Maybe the ladder wobbling caused her to twist her body?
Yeah, we stand by the expert's opinion that the mechanics of her her fall happened as so. If you have any other questions,
Thank
more
you,
than
counsel.
thank you.
Both. People v. Baron Williams.
It's miserable. Designed for big white men.
Good afternoon, Your Honors. My name is Hillary Dowling, appearing on behalf of Appellant Mr. Baron Williams. We are asking the court to reduce Mr. Williams' sentence upon his guilty plea to gun possession in the interest of justice. Although it is true that Mr. Williams was initially charged with homicide-related offenses carrying the risk of significantly higher sentences, under the particular circumstances of this case, sentence reduction is warranted. This is because the prosecution conceded, based on its own evidence, that Mr. Williams was acting in self-defense at the time of the shooting, all but negating the possibility of conviction on the higher offenses charged in the indictment. In sum, he pleaded guilty to the only count of the indictment for which the prosecution, by its own account, had sufficient evidence.
But it was still 1.5 years above the minimum, the carceral sentence, right?
Yes, that's correct.
So you want to go to 3.5 and 2.5 PRS, right?
That's correct.
Please continue.
We are asking the court to consider Mr. Williams' excessive sentence claim in this unique context. He was just 22 years old at the time of the offense with no prior criminal convictions. And as Your Honor just noted, could have received a sentence of 3.5 years prison. With
I know that people set forth quite a bit of criminal conduct in 2017, YO situations. I mean, how does that get considered? I mean, obviously the people are setting it forth in their briefs, so they think it's something that we should be considering. I mean, doesn't he have like 4 prior contacts of that type?
He had 2 family court adjudications and 1 YO adjudication
He
prior to this.
had a YO for criminal possession of a weapon in 2017. He gets 3 years probation and he violates the probation. He had juvenile offender convictions. Didn't he have that also?
Yes. I think that...
Attempted assault, attempted robbery, and assault 3?
Yes. I think that I did cite cases in my brief where this court has reduced excessive sentences in gun possession cases where defendants were second violent felony offenders and convicted after trial. I also noted cases and examples in my brief where a first-time felony offender charged with gun possession often receives sentences less than the minimum we're requesting in this case, oftentimes 2 years or less. The fact that he had a prior YO adjudication may have meant that he would have received more than that typical 2 and 2 offer that is done by the Bronx District Attorney's Office, but without the later learned unviable, much higher and much more serious counts in this indictment, I think there's very good likelihood that he would have received this minimum sentence that we are now requesting here.
What's the maximum sentence he would have potentially gotten? What was the maximum exposure if he didn't take this?
On the homicide counts?
What was it, 15 years? 3.5 to 15?
3.5 to, as a first felony offender, I believe
criminal
that's correct.
possession of a weapon, 3.5 to 15 years?
I believe that's correct, yes. Yes, but, you know, obviously, it's well accepted that, you know, that a greater sentence was hypothetically possible does not mean that the sentence Mr. Williams received was substantially fair. And I think that under these circumstances where Mr. Williams has never disputed the serious nature of the offense and the tragic consequences that resulted, under these circumstances, the people have essentially conceded that when armed, the decedent and other individuals violently confronted him, armed and displaying firearms, Mr. Williams acted in defense of his own life. And I do think that under those circumstances, the minimum sentence here is warranted.
Does the record reflect what the defendant tells the police when they come to question him or arrest him?
Can you repeat
Does
that?
the record reflect what the defendant tells the police when they come to question him or arrest him after the shooting?
I did not have that in the appellate record. I thought that that was mentioned in the respondent's brief. I'm not sure what that was in reference to or where it derived from, but I would just note a 22-year-old young man who's being confronted by police in the immediate aftermath of an offense like this.
Is this the case where he tries to blame a different individual when the police approach him?
I'm not aware of the record on that, but even if that was the case, I think it became clear later that that may have been an initial statement while he was fearful about the consequences of this, regardless of him acting in self-defense that can be understandable, and certainly 3.5 years in prison would be sufficient to cover the crime charged here, again, under these unique circumstances. I know that I didn't address the appeal waiver, but I can do that on rebuttal if necessary. Thank you.
Kevin Peterson for the people. May it please the court. As your honors discussed, just 2 years before the instant offense, defendant received a YO adjudication for illegally possessing a firearm. He violated the probationary sentence on that YO adjudication and then clearly violated it again in the instant offense by possessing a .45 caliber pistol that he used to shoot and kill Pablo Casiano. He could have received up to 15 years. The minimum was 3.5, so he received a near minimum sentence.
What was the people's request for sentence? What was the people's
The
request for
people
sentence?
negotiated and worked out a plea offer to 5 years incarceration and 5 years post-release supervision, which defendant and counsel had 10 months to discuss, as well as the appeal waiver. And he wisely accepted this offer, realizing that it was quite lenient. Also, as Your Honor mentioned, defendant, when confronted by the police immediately after the incident, did not mention self-defense. Instead, he falsely accused an elderly neighbor of being the true culprit. So in totality, this 5-year sentence of incarceration as well as 5 years of probation.
The
quite
defendant
lenient.
remains incarcerated?
Our information is that he is currently incarcerated on an unrelated matter.
He served the sentence, he's served the incarceration portion of this sentence.
I believe
Because
so.
I mean, I note that it's a 2021 plea, so, and it's 5 years. You would have expected that he would have been released, probably. But you say he's incarcerated on a different charge?
That's the information that I have, Your Honor. We also assert that the appeal waiver was valid in the totality of circumstances. Defendant and counsel discussed it.
Points out that the court interrupted him when he was asking a question during the course of the colloquy. So does that invalidate the waiver?
Your Honor, that does not invalidate the waiver. The fact that defendant asked a question shows that he was actively engaged in the colloquy. He was listening and thinking about what was said. He appears to have been satisfied by the court's response to his question, even though it wasn't fully put on the record. And he also discussed the court's colloquy with his attorney.
Didn't the court fail to list some of the most important appellate rights being waived?
The court's colloquy was not the model colloquy. However,
That's kind.
it did mention that the appeal rights were separate and distinct from the automatically waived trial rights, which is very important. And it did list many of the specific claims that would survive and those that would not survive. And defendant signed the written appeal waiver in open court after discussing it with counsel. So it was a valid waiver in our view. And as mentioned, this sentence is eminently fair and quite lenient in light of defendant's history, as well as the serious consequences of his illegal possession of this firearm while he was already on probation for possessing a firearm previously. So we think that the 5 years of probation is also very important, in addition to the 5 years that he may have already served of incarceration. If your honors have no further questions, we rest on the papers. Thank you.
Thank you, counsel.
I will just note that although it's obviously a YO adjudication is something that this court can consider in determining whether this sentence was just, this court again has reduced or excessive sentences, or just let me double check that. Or there's several sentences where people had an actual criminal record or a violent felony criminal record where they received the equivalent to what Mr. Williams received here, even though he pled guilty instead of going to trial. So taking a prior YO and saying that that in and of itself justifies this higher sentence, I don't think is consistent with the prior plea agreements with similarly situated defendants or even defendants situated in a more dire position than Mr. Williams. I will note just a couple things about the waiver. It is invalid and unenforceable in this case. It was never explained that it was an automatic consequence of pleading guilty. The court never explained the nature of an appeal, just told him that he was waiving it definitively. He was precluded from answering a question, as this court noted, which there's no way for this court to adequately ensure he understood the rights he was giving up and the rights he was retaining. And I think really critically, the court mischaracterized the scope of the waiver and informed Mr. Williams that constitutional errors would survive a valid waiver, where in fact, most constitutional errors are in fact waived by a valid waiver. And I think that the signing of the written waiver, again, has no bearing on curing this deficient colloquy where it was ultimately mischaracterized. As this court has noted before, he was never asked whether he had read the written waiver, discussed with its attorney, or understood its contents. He was 22 years old with limited experience in the criminal justice system, and the written waiver itself fails to explain that the right to counsel in poor person relief survives a valid waiver, and in fact suggested otherwise. If
Thank you,
there's no
counsel.
further questions.
Thank you both.
Thank you.
Bovee Anthony White. Please.
Nikita Kandra of Latham & Watkins for Appellant Anthony White. This is a case about putting the government to its proof as to what it must establish beyond a reasonable doubt to convert a $50 shoplifting charge into a felony burglary conviction, resulting in a multi-year prison sentence. Mr. White acknowledges.
Is your argument primarily on the legal sufficiency or the weight of the evidence?
We are bringing a challenge to the weight of the evidence, and we've never brought a challenge to the legal sufficiency.
Okay, so you agree that that was not preserved?
We agree. What we don't agree with is the people make an argument that on weight of the evidence review, you cannot consider the elements of the crime. But People versus Danielson and other precedent from the Court of Appeals and this court make clear that in weight of the evidence review, you necessarily must consider the elements of the crime. It's part of the inquiry of first whether an acquittal would not have been unreasonable, and then also weighing the evidence that was before the jury and seeing whether the jury was justified.
In your argument, that brings us to the trespass admonishments, right? The document that was issued allegedly by Dwayne Reed to the defendant, saying don't trespass in our stores. And your argument is that he didn't receive it? He didn't know about it? What's your argument precisely?
The government brought 5 notices to trial, and they really focus on 2 of them. One of them is a July 2019 notice, and that notice was not signed by Mr. White. Mr. White also provided testimony at trial that he was told by the officer who was dealing with the notice with him that he was not to come to that particular store ever again. So that was a Rockefeller Center store, not the 7-Eleven 3rd Avenue store that is at issue with the larceny here. And
that officer didn't testify, correct? There was no one who testified that, there was no officer who testified that he or she gave the 2019 notice to the defendant.
Exactly. This is the remarkable case where the government did not bring any direct witnesses to the trespass notices being issued, supposedly, to the defendant. Mr. White was the only witness to testify from his personal knowledge about any of these trespass notices being delivered or not.
I may be mispronouncing his name, but Mr. Palawal, I believe, testified to the normal course of conduct when someone is found boosting stuff from Dwayne Reed's. In other words, that this is how we do things, and is that sufficient?
No, Mr. Palawal talked about the trespass notices as a general matter, what the practice is. But what we don't have here, and what is very different from the cases that we cite at pages 19 through 21 of our brief, where this court has upheld burglary convictions on the basis of trespass notices, is any direct evidence of the ban, of a lifetime ban on all Dwayne Reeds being personally communicated to Mr. White. There was no store employee, there was no video evidence, there was no police officer testimony.
Mr. Halliwell testified, didn't he, that the Dwayne Reed practice was to hand over the notice to the police department for them to give to the defendant, correct?
Exactly. At page 69 of the trial transcript, Mr. Pollywall testifies that the police are supposed to be involved in getting the notice signed and handing it over to the individual. At page 50 of the trial transcript, another store employee who testified, again, as to the larceny, but not as to any of the trespass notices, she also says that it's their job to get the police involved at that point.
I just wanted to ask, Mr. White admitted that he received the notice, right?
Only as to the January 2006 notice, he admitted that he signed the notice, but he testified, and again, there was no affirmative case from the government otherwise, no witnesses saying otherwise. He testified that he was told that that notice only lasted 7 years and was limited in application to the particular store that issued the notice.
But that's not what the notice said, though, literally.
The notice does set forth a broader ban, and that's where it's kind of critical to put the government to its proof here. So in all the other cases that we cite in our brief regarding these trespass notices, the government provides further evidence, testimony that connects the dots between the words of the trespass notice and the defendant actually having been personally communicated and understood the scope of the trespass notice.
So there is a January 19, 2006 notice that's signed by the defendant, isn't that so?
Correct.
Or at least seems to bear his signature.
Yes, and that 2006 notice is the one that Mr. White testified that he was told only lasted 7 years. And
the jury didn't have to credit his statement that he was told it only lasts 7 years. Does the notice say it lasts only 7 years?
No, the notice does not say that it lasts only 7 years. But
the jury can believe him when he says he signed it and not believe when he says, I was told it only lasts 7 years.
Well, this is the rare case where it was against the weight of the evidence because the government put forth no affirmative case otherwise. There was no one contradicting Mr. White's testimony regarding the scope of the trespass.
This notice was admitted into evidence as People's Exhibit 5E, right?
That's correct.
And does the notice say it's only good for 7 years?
No, the words of the notice don't say that. But again, as all the precedents from this court show, the government typically does put forward more proof, and here the government didn't do that at all. And without
well, it's not the only note. There are other notices which the people claim were given to the defendant, which are not signed, but this is one which is signed.
Correct. So 4 of the notices that the government put forward were not signed, and then the single signed notice, the 2006 notice, was issued more than 15 years before the alleged larceny here. It was
not
also
all
from
that the people's case rests on is the 2006 notice.
Can you say that one more time?
I said the only thing that the people's case rests on is not the 2006 notice.
They focus primarily on the 2006 notice. They discuss the other notices as well as the 2019 notice, but the 2006 notice is the only one that Mr. White signed. But again, the only testimony from anyone who was there when the notice was issued is Mr. White's testimony. And he said—
As to the other notices, there was no testimony as any person personally communicating to Mr. White, as required by Penal Law 140, that it had been given to him, right?
Exactly. There was no direct witness testimony as to those trespass notices being issued. And that's remarkable because in many other cases involving trespass notices, the government does put forth the video evidence from other witnesses, and more evidence, again, to just connect the dots between the words of the notice and them having been personally.
Definitely make that point very well in your brief. Thank you. You have time in rebuttal as well. Please.
Good afternoon, Your Honors. Jamie Masson for the people. In the cases where the people have turned to live testimony of the individual who did communicate the trespass notice to the defendant, or in cases in which we have introduced video, those are instances, for example, in People v. Goodson, where the people did not introduce into evidence the actual trespass notices.
But this trespass notice doesn't show on its face that anything was personally communicated to Mr. White, does it?
I believe it does in two ways.
I read the transcript, I looked at that trespass notice. I don't see anything that says that that was personally communicated to him.
Sure, it's a circumstantial
Perhaps you could tell me where.
Sure, it's a circumstantial conclusion, but one I think the jury fairly made. The January 19th, 2006 trespass notice is signed by the defendant. He admits it on page 90 of his testimony. And his signature on there, his admitted signature on there, represents what the trespass notice says, that I, Anthony White, understand that my privilege to enter all Dwayne Reed stores
I
is
have it in front of
revoked.
me, but nothing on there says that it was personally that anything about it was personally communicated to him, either on the face of it or in the testimony.
That's correct.
Personally communicated, I assume, has some meaning. It means that a person has to speak to him. Where is that established in the record?
Again, I think it's by the signature. I understand Your Honor's point. We are making
Okay, let's try this a different way. Do you agree with me that there's nothing in the record establishing that it was personally that anything was personally communicated to him about the January 19th, 2006 trespass notice?
I'd agree that there's no live testimony and there's no video. I would dig in.
If the notice communicates this to him and he signed it, doesn't that constitute a communication?
Yes, exactly. And that's why his admitted signature on the trespass notice itself is so monumental and, in
I mean,
fact,
there's no
devastating to
prescribed allocution that needs to be presented of how this is done. If you give him a notice telling him that he can't come into these stores and he signs it, is that not enough?
That's exactly right. I think that is enough. And in fact, it's not just.
How do we know that it's an authorized person, which is also required? There's no evidence that, assuming it was given to him by somebody, how do we know that that was an authorized person? Even if you can infer that it was somehow given to him, how do we know it's an authorized person, which is very clearly required?
Sure. So stepping back, this idea that this wasn't a lawful order, that it wasn't given by an authorized person, was not disputed at all. It basically wasn't an issue at trial. And the idea that we failed our burden as a matter of law to prove that is a pure, naked.
You mean at trial the defendant did not challenge that it was given to him by a person who was not authorized?
Exactly. They didn't challenge it. They didn't bring it up in a trial order of dismissal.
Anyhow, if the fact that these notices were given to him repeatedly, he didn't sign them. When he did sign, isn't it a fair inference that the person giving him the notice is someone authorized to do it? I mean, someone isn't coming in off the street and giving him a notice and say, don't come into Dwayne Reed.
Exactly. Setting aside that this is an unpreserved legal sufficiency argument which cannot be raised under the guise of a weight of the evidence argument, there is evidence in this trial as to the fact that this was a lawful order given by an authorized.
Wait. As to the other four orders other than the January 2006, what connects those orders to him and shows that it was given to him? His name is on those orders, but that doesn't show that it was given to him.
Sure, his name is on them, and I think that represents.
Yes, I know his name is on them, but what shows that it was given to him?
There's a marking.
There's a box, right, that says, check if subject refused to sign, and that's checked a couple times. So do we draw the inference from that it was someone attempted to give him the form?
That's exactly where I was going, Justice Moulton.
Why isn't that hearsay?
Because it's a marking on a document that was introduced into evidence.
Right, but the fact that it's introduced into evidence doesn't mean that everything on it meets the hearsay exceptions.
Had they made that argument below, certain portions of the document could have been redacted, but they didn't. So the idea that the jury couldn't rely on that marking is unpreserved. But even still, the marking is a check.
Did the defendant object at trial that this can't be considered because it's hearsay?
Not at all, not once.
Counsel, what do we also, he's been convicted of the same offense before, and it's come to us before, and we've affirmed there was different proof at trial. But does that also give some notice? Is that sufficient? What is the import, if any, of the fact that he's already been, his conviction has already been found not infirm by this court for under the exact same circumstances?
I think it strengthens it. I think that coupled with the testimony from the Duane Reade employees that shoplifting is a rampant problem within their stores, that the trespass notice is a tool used by Duane Reade to combat shoplifting. I think it fairly flows that they are authorized as employees to use that tool in response when they're on the front lines confronting shoplifters who are taking items from the store. I would like to just touch upon one final aspect.
30 seconds, Councilman.
Sure, we don't dispute that this court can look at each element under its weight analysis. What we dispute is the way in which the defendant asked this court to go about it. Because the question in weight is not whether there are other possible ways that we could prove this case or whether there's other proof that we could have introduced. The weight question simply, did the jury fail to give the evidence the weight it should have been accorded? And looking inward towards the trial record, there's no reason to disturb the way in which the jury made its fact-finding decisions.
Thank you, Councilman.
Thank you.
2 points, Your Honor.
Counsel, could you address the fact that defendants' counsel's failure to raise any objection to the 4 trespass notices other than the January 2006 one means that one has to simply accept that those were given to him and that the refused notation on those means just what it says?
Yeah, it's our position that that's not at all what would follow from the notices having come into evidence. So on page 101 of the trial transcript, the defense counsel below makes pretty clear that he's challenging the fact that there is no video evidence, that there is no direct witness evidence of the notices, and he discusses what evidence did come out about the notices and how they undermine the government's story of the notice. He discusses the fact that Mr. White, the only witness to testify as to these notices, testified that the January 2006 notice, what was personally communicated to him was that it lasted only 7 years, and that the July 2019 notice, what was personally communicated to him, was that he was not to return to that specific store again. And what defense counsel does below, and preserves our challenge here as to the personally communicated element, is he explains and he even says, like, if that's not reasonable doubt, I don't know what is. And I want to address the fact that the people are resting entirely on these sheets of paper without, in many instances, any counter signatures and without any evidence connecting the dots and buttressing what these notices are supposed to mean. One can imagine a variety of scenarios in which a store employee starts filling out a notice, for instance, and maybe knows the name of the person leaves the store before they are given the notice, but the notice is as filled out as the notice is here. Or for instance,
of that here.
Can you say that one more time?
That's just speculation by you. I said there's no evidence of that here. This is just your speculation.
Yes, that's not what we're saying necessarily happened here, but it's an example of why the government needs to be put to its proof here, why a sheet of paper is not enough. One can also imagine a scenario where someone is told to sign a sheet of paper and not to return to the store again, but what they don't know, what was never personally communicated to them, is that there is a lifetime ban against them as to all Duane Reade stores. That is possible, and that's what Mr. White testified to here, was that he was told of a ban that was limited in time and space.
Thank you, counsel.
Thank you.
You did this case pro bono, did you not?
Yes.
Thank you very much, and thanks to your firm for lending you out as well. Thank you both. Fondela, v. 345 West 70th Tenants.
Good afternoon, Your Honors. My name is Charlotte Bickman. I represent the plaintiff, Paul Fondela. Should I repeat it? Your Honor, apparently you're hearing two dockets, two case numbers.
Move it closer to your mouth, please. Thank you.
Apparently, you've just informed me today that you're
Yes,
hearing
it's a
both
Baroque litigation. It's been going on for some time, so we pick whichever issues you think are the most important for us to consider.
Okay, as a starting matter, general obligations law provides a remedy where one party to an executory accord fails to fully perform its obligations under the agreement. That remedy is that the other party has a statutory right to restore the original action. In this case, a defendant did not fully perform its obligations under the stipulation of settlement in the original action.
Restoration to the same docket number is not mandatory, though, correct? In other words, the court was had discretionary powers to order you to bring a plenary action, a new action.
No, I disagree. It said specifically one of the remedies is to restore the original action. So in the cases which I cite, the seminal case is Plant City versus, I believe it's American Mechanics. The one party did not fulfill its obligations, and the other party brought a motion to restore in the original action.
But here, that made less sense because he's already sold the apartment. So the situation on the ground has changed significantly, making it unrealistic to go back to the original lawsuit.
The original complaint requested money damages. I believe it was over $100,000. So the issue is money damages at this point. There's not a request to...
What effect does his sale of the apartment have on these rights that you're trying to assert?
Actually, with respect to money damages, no effect at all. Because the issue is damages which were accrued during the period that the...
So where does the stipulation fit into that?
Pardon, Your Honor?
Where does the stipulation fit into that?
Well, in this case, under the statute, the stipulation was an executory accord, a promise to do something in the future, and the statute provides specific relief, a specific remedy where one party breaches that stipulation. That's the remedy that it provides. And this is a remedy for a particular kind of
What are the
settlement.
damages that you're claiming?
Pardon?
What are the damages that you're claiming?
Well, the damages on the warrant of habitability is rent abatement. The damages are...
He no longer lives there.
Up until the time that the apartment was sold.
So you
This has gone on, as you say, for a number of years. So
you need to bring in the second action that your client started.
the second action was brought in 2021 on a different issue because the proprietary lease remained in effect underneath the terms of the stipulation. Plaintiff was served with a notice to cure on March 5, 2021, and that was, in our opinion, a predicate notice to try again to take his shares. So we went into court. We had to stop that action. They withdrew that notice to cure after Justice Cohn made it clear at a hearing on the TRO in order to show cause that there wouldn't be any seizure of shares under that notice. So that forced that action, but at the time they hadn't done any repairs, and so the issue of warrant of habitability post-stipulation was also then brought before the court. But the point about the general obligations law is it provides a statutory remedy for a particular kind of contract. That is an executory contract. The court below didn't even address the specifics of the statute, but said that, denied that relief, saying that the parties can't be returned to the status before the stipulation. Well, under that kind of reasoning,
your client wasn't deprived of that right. He did. There was a plenary action where he is asserting all these claims.
Are you talking about the second action, the subsequent one?
Do you agree that he has asserted the claims? I mean, there are
two different time periods
with another action here.
Well, there are two different time periods, and then, you know, this raises questions about perhaps statute of limitations and so on. That's why they allow you, under the statute, the general obligations law, to restore the original action. I mean, the language is really crystal clear in the statute. So what I suppose defendant is arguing is, well, don't give them the benefit of the statute. But as I noted, it's for executory accords. So it's an exemption from other contract analysis issues. And it also obviously applies to what would otherwise be a valid settlement or valid contract.
Counsel, that is a point that the other side makes, with that you're simultaneously trying to enforce the stipulation and also trying to avoid it.
No.
How do you get around that contradiction?
No, the enforcement in the second action, because we have HBD and the DOB violations were issued after plaintiff signed the stipulation. So the second action also involves enforcement of the HBD and DOB violations. Those are orders from city agency.
Right. The other side says that those violations were something not contemplated by either your engineers or their engineers. It was another part of the apartment that had an issue, the DOB. Is that true?
No, the DOB violation has to do with was raised in the housing court, had to do with the defendant's president removing a load-bearing wall, and because of the construction in this 1905 building, the wood vertical supports in 3A, plaintiff's apartment, rested on the vertical supports in 2A. And when 2A did his renovation in 2015, he cut them so that the supports had the vertical supports were no longer attached to anything. That was raised in the housing court.
Thank you. You have time, rebuttal.
Good afternoon, Your Honors. Daniel H. Richland, Falkowski PLLC, attorneys for the respondent. I think the easiest way to understand why exactly we're here is, as you said, it's because the appellant would like to avoid the stipulation now that he realizes that his claim is effectively limited, as per Your Honor's prior order in the 2021 action, to the period between January 2020 and April 2022. And he wants to avoid that and go back further on his warranty of habitability claims despite settling those claims. And I think that's really what this is about. The problem is that can't be done because we performed under the stipulation. As Your Honors are aware, the stipulation has a protocol where the engineers determine the scope of the work, and then we perform. There's no dispute that both of those events occurred. So there was no breach by the respondents. What happened is there's this additional violation.
Was there any evidence that those original problems were cured?
In this record, I believe it's undisputed that all of the violations that were stated in the stipulation have been resolved, but one, which affected a different room, which was unknown at the time. That's why the engineers didn't do that. And bear in mind, we as the parties, both parties here, had no input in what the engineers determined as the scope of the work pursuant to the stipulation. So the engineers looked at the violations, they determined what the scope would be, and then told us what work had to be done pursuant to the plans that were filed. And then that work was, in fact, performed. It was only after HPD came and inspected that it was discovered that one of those violations had not, in fact, been cured. Having said that, there was still, pursuant to the stipulation, no default notice by the appellants to us, which would have required us to cure. And by the way, this process would have required them to spend money with their engineer to come up with a new plan to cure this one specific violation. We were happy to do that, but they sold their unit instead. They bought it for $80,000 in 1980, and they sold it for $1 million in April 2022. And as the record reflects, you have an affidavit from the present owner who says he doesn't want us to do this work. So I don't see how we could possibly be in violation of the stipulation under those facts, which is why, as a condition of the stipulation.
Also, the new shareholder is the one who has rights under the stipulation now, correct?
Exactly. It inures to his benefit pursuant to the explicit terms because he has the right to determine what work, and the stipulation explicitly says that it inures to his benefit. And he has said he does not want us to cure this remaining violation. If he doesn't want us to cure this remaining violation, we don't have to. He can waive that performance. I can't force a tenant shareholder in a co-op to do this when he's planning to do his own renovation and wants to do this himself. That's his right. So what remaining rights here under the stipulation do the Fondelas really have? But the purpose of doing this is to avoid the general release provision that occurs once this work is complete, or waived, really.
What is the import, if any, of Justice Billings' decision? She's one of the many judges who touched this case.
Yes, Baroque, yes, that's very true. There's really none because she denied our motion on essentially evidentiary standards. Even though that's an e-filed case, and even though the general releases were e-filed in that case, they weren't attached to the motion, or she didn't see them or review them, and she denied my motion to basically force them to give me a general release at that time, and then...
But the issue was one of proof at that time.
Exactly, correct. She didn't decide we weren't entitled to them. She didn't decide there was a, the stipulation had been breached or violated. She just said, you haven't made a sufficient factual showing, sufficient evidentiary showing, which has no real basis. It's like a denial of a motion to dismiss or a denial of a summary judgment motion. Sometimes in those motions, you have a factual determination, and that was not this case. She didn't decide anything. She just denied the motion, saying it's insufficient. That, frankly, that's a fairly common occurrence throughout the courts in the state. So I think what you need to keep in mind is what the real purpose of this. In the complaint in the 2021 action, the petitioner, the appellant, relied heavily on the stipulation. It's paragraphs in that record, 25, 6, 27, 34. It's on pages 27, 28, and 29 of the record there. Literally, explicitly is talking about how we need to perform under the stipulation. And now, when that means that it cuts off portions of her claims that she wants to revive because the dollar figure, the $80,000 that she maxes out between January 2020 and April 2022, which also coincides with COVID, because she doesn't want to limit herself to that number, because $80,000 is not enough money for this claim, to litigate this claim, to bring repeated appeals and to litigate this and to do discovery, she wants to expand it. But you've already cut that off. You've already indicated in your prior decision in the 2021 case that the stipulation is valid. She didn't give a basis for vacating it. She hasn't given a basis now to vacate it. And it's already been performed with the rights, the remaining rights at that time, waived by the new owner. So practically, there's nothing left other than to give us the general release, but that's for the litigation. That's for summary judgment below. We're here on two different things. We're here on a motion to dismiss, which was not addressed here about the counterclaims. And then we're also here because she wanted to vacate the stipulation under a number of different grounds, of which the only one she's now arguing appears to be GOL 15-03. But that doesn't really help her because, as you said, that's non-mandatory. And the court basically said, bring a plenary action if that's what you want to do, or we can flesh this out. Because Fondela 3, which is the action that's occurred in the 2019 action, doesn't talk about the stipulation that way. There was no stipulation at the time. And the stipulation gives continuing jurisdiction, not exclusive jurisdiction. And we have a forum, the 2021 case, where we're literally addressing this issue on this counterclaim and exactly what the rights are. But that's why we're here. Thank you, Your Honors, unless you have any questions for me.
Thank you, counsel.
Your Honor, defendant has numerous times stated that the co-op fully performed its obligations under the lease, but it's never produced any admissible evidence backing up that statement. The plaintiff produced the HPD documents, certified records, which show that they did not repair the back bedrooms. Contrary to what he said, plaintiff's engineer very specifically said that plans submitted by their engineer covered only the southern portion of the apartment, the living room, dining room, kitchen, and adjacent bedroom and hallway. So he's very specific that those plans were limited to that portion of the apartment. In addition, violations cannot be waived. It's clear that the back bedrooms, there were violations issued April 25, 2019, and the stipulation, if you're going to rely on the stipulation, specifically said that those violations had to be cured and removed. And it's undisputed that they did no work in the back for the back bedrooms. Again, Justice Billings denied, with respect to the counterclaim in the current action before Justice Cohn, Justice Billings' decision was a decision on the merits. They brought in a motion for specific performance, alleging that they had fully performed their obligations under the stipulation and was entitled to a release. When Justice Billings wrote that they produced no witness attestation on personal knowledge, she was denying the motion for specific performance on the merits. Justice Cohn, when he did not dismiss the counterclaim, claimed that it was not a decision on the merits because it was dismissed for lack of evidence. That contradicts established precedent by the First Department, which is set forth in my brief, which says the issue on collateral estoppel, which is what is raised in this subsequent action before Justice Cohn, the issue is opportunity to litigate, opportunity to present evidence.
Thank you,
Clearly,
Counsel.
they had that
You
opportunity.
make that point in your brief. Thank you. Thank you both. Matter of Wells Fargo Bank, the HBK. Please.
May it please the court, Julius Chen for Appellant HBK Master Fund. As in any contract interpretation case, this court must construe and apply the text to the record. On the first question presented, whether deferred principal payments are subsequent recoveries under the PSAs, reversal is warranted for failure to satisfy either the all amounts or the liquidation requirements. We think the trial court's errors are clear on both fronts, but just to take liquidation to start, whatever liquidation might mean in a vacuum, trial made clear that the PSAs incorporate the Fannie Mae Guide, which in turn expressly defines liquidation to mean extinguishment of a loan. Wells Fargo also repeatedly told investors and its witnesses testified at trial that one, forbearance is not the same as liquidation, and two, the loans at issue remained active, performing, and fully due and payable. We think that settles the liquidation matter.
But Justice Borak went off a great deal on the parties' behavior with respect. So doesn't that obviate what you just said?
Well, no, Your Honor. And I would say two things about the course of performance here and why it cannot carry the day. The first thing is that we still need a textual anchor in the PSAs, even when we are talking about extrinsic evidence and specifically course of performance. We do not engage in a free-roving atextual inquiry, and that means we go to the two requirements, which we all agree are requirements to be subsequent recoveries. And as I was explaining, the PSA's meaning is clear post-trial. I just walked through the liquidation. I'm also happy to walk through the all amounts. The second point that I would make with respect to the course of performance is here, I think it would be especially odd to rely on the course of performance because Wells Fargo, while it has a course of performance at least since 2013 to say, hey, these should be subsequent recoveries, we don't really think that counts for that much because they're not interpreting the PSAs. You can see this in interim position 55, that's at A3855. And what Wells Fargo is saying, at least internally, is that we've looked at these documents, we've looked at the PSAs.
Counsel, just to dial it back a little bit, you just said, didn't we already find that the PSAs are ambiguous? And that was the whole point of this trial. You just said they're clear. So we've already found that they're ambiguous.
So Your Honor, what I would say about the ambiguity is that the ambiguity, the way we read that sentence, is to say, it's how the PSA's terms actually apply to the deferred principal payments. And yes, at that point, the court didn't have a record. And just remember, at that point, Justice Borak also hadn't looked at a single piece of evidence. He hadn't interpreted the contracts either. He just said, hey, I think JPM2 is sufficient here. And the court, of course, reversed. And then it said, hey, let's remand because there are one, factual disputes. And again, what the court, we think, is saying is that the PSAs, they don't say anything specifically about deferred principal payments. But the reason I think it's clear is because we're talking about post-trial now. I'm not trying to say ex ante. I'm saying post-trial, again, with respect to liquidation, as my example. Everything points in one direction. There's, again, no dispute that the Fannie Mae Guide is incorporated expressly, and it defines liquidation to mean extinguished. That's at 338.7.
There's no liquidation here because those loans are still active.
Yes, that's my point. And just to be clear, we're not living and dying on the Fannie Mae Guide here. And this goes to Justice Moulton's question, I think, right? It's the totality of evidence, we think, on something like liquidation that makes this crystal clear that while, yes, there might have been a course of performance, they're not interpreting the contracts here. And when it comes to the specific requirements of the PSAs, which is what this court has to look at in the end. Again, it can't just say, hey, this is a free-roving inquiry. We're just going to ask whether or not Wells Fargo did this or didn't do this. That's not the way we think the contract interpretation should be done. And so, yes, I would completely agree, Justice Chan.
Yet you say that the PSA does not provide for applying the deferred principal payments to senior certificate holders. I mean, we're back at the ambiguity.
Well, Your Honor, I think that goes to the JPM2 point, which is already resolved here. It's not really at issue here whether or not the seniors get written up or not, I would say. We're at the question of whether or not there's subsequent recoveries. If there are no other questions on the first question presented, I'm happy to cover the second question presented here as well. And there, I would just say that if deferred principal payments are not subsequent recoveries, we think the text also answers the second question presented. Such payments are principal funds that must be distributed through the agreed upon waterfall, and I'm happy to
You can
unpack
that at greater length on rebuttal. Thank you. Please.
Good afternoon, Your Honors. Caitlin Halpern for the senior certificate holders. For more than a decade, Wells Fargo reversed losses to senior certificate holders upon receipt of deferred principal payments without objection from any party, despite strong incentive for the junior holders to do so. That was the party's behavior. That was the course of performance that was known and
Then
acquiesced.
JPM happened.
I'm sorry, Your Honor?
Then JPM happened.
And as this court previously held, JPM did not address whether deferred principal payments are subsequent recoveries. It addressed an entirely different issue of whether funds that were indisputably, that everyone agreed were subsequent recoveries, how those funds should be distributed. And so for that reason, none of the briefing, none of the decisions in JPM mentioned deferred principal at all, much less speak to the question of whether deferred principal is a subsequent recovery. But you're correct, Your Honor, that the subordinates are relying on JPM2, that after their decade plus of silence, the juniors try to take that decision to ask this court for a
But the fact
yes,
that
Your
they
Honor.
were silent doesn't mean that they are limited by that if they were wrong based on what the contracts, what the PSAs say.
We certainly look to the text first, as Mr. Chen did, but the problem there fundamentally is twofold. The court could not find a liquidation, as Justice Chan noted, because there's no extinguishment or settlement of a debt or obligation, nor could the court find that there was a liquidated mortgage loan, because there was no servicer determination that all amounts expected to be recovered had been recovered. Testimony supporting that included testimony from the junior holder's own expert witness that servicers made no such determination. Those are two absolutely fundamental prongs of the subsequent recovery definition under the PSAs. So the text forecloses the interpretation that the trial court went with, and to the extent the court has lingering doubt, the course of performance is also conclusive. Because again, the party's behavior, what was known and acquiesced to, was writing up senior certificates for over a decade without any objection. To briefly hit the follow-up question for the court, what to do given that deferred principal payments are not subsequent recoveries, there's a mantra that the trustee and subordinates have adopted, but ironically, it's actually the senior certificates who advocate for a two sides of the same coin solution. For years, the trustee, following Treasury guidance, went outside the PSAs to write down deferred principal at the time of modification. And Wells Fargo, in emails and in testimony, recognized that that's what it was doing, going outside the PSAs.
And that happened post-HAMP?
That's correct, Your Honor. And so now, consistent with the intent of both the PSAs and the Treasury Department, as testified to by the person who wrote that guidance, the trustee should simply reverse those losses and write the senior certificates back up, again, as it did from 2009 to 2021, without objection from any party. This court has recognized in cases like Herbert Rosenthal Jewelry that when parties to a contract fail to anticipate a particular situation, it's reversible error to reach an unjust, unreasonable, and uncontemplated result by the parties. Our briefing details several categories of evidence that show that the trial court's result was unjust and unreasonable here. Again, we begin with the text. A liquidated mortgage loan requires a servicer determination that all amounts expected to be recovered have been recovered. Not some amounts, not all but de minimis amounts, all amounts. Again, the subordinate's own expert conceded at trial that servicers never made that determination, nor could they have, because in order to grant HAMP modifications at all, servicers were required to find that the anticipated recovery was greater than it would be if there was forbearance. Again, the course of performance, the trial court and respondents make the same error. Both focus on the reason why the trustee supposedly wrote up senior certificates or what the trustee believed. But the trustee's subjective internal beliefs are irrelevant. As this court is well aware, the course of performance refers to objective conduct that was known and acquiesced to. It was undisputed at trial that investor knowledge came primarily from remittance reports. And what investors,
I'm sorry,
from remittance reports, Your Honor. And what investors knew from those reports that were issued in every trust every month is that Wells Fargo wrote up senior certificates. And it did that regardless of the language of the PSAs, specifically regardless of whether the particular PSA for that trust provided that everybody gets write-ups or that write-ups are for subordinates only. Importantly, those remittance reports also identified modified loans as active, whereas other loans were identified as liquidated. One loan, and Wells Fargo expressly stated in that same reporting that it was treating deferred principal as losses or gains, a loss when reported by a servicer as a loss, and then reversed to be a non-loss when the servicer changed that reporting. Again, that's what Wells Fargo did for more than a decade, and that's the relief the senior certificate holders seek here.
Thank you, counsel. You have time in rebuttal. Please.
Thank you, Your Honors. Mark Titici for Wells Fargo, one of the respondents here. Your Honors, I want to start, I guess, with Justice Moulton's question about the prior decision here and the ambiguity finding there. Both of my colleagues on the other side have made points about the supposedly clear text of the PSAs. But let me be clear. In the first appeal, they made the same arguments they're making here based on the same text. So they argue now that you can't, the modified loans can't be liquidated mortgage loans. They make the same argument in the first appeal. Deer Park's brief made it at page 20 of their first brief. The seniors and HBK had a joint brief there, joint brief page 5. The after liquidation point my colleagues just made, they made it Deer Park's brief page 20 of the first appeal, the joint brief page 17. They made the same textual arguments based on the same textual points in the PSAs that they've made to you today. This court wasn't persuaded then, and there's no basis in the supposed evidence at trial for going back on that. If they're right, if they're correct that the evidence, that the PSAs are clear, you couldn't consider the trial evidence. This court has said time and again, you can't impeach a clear contract based on extrinsic evidence. So if they're correct about the face of the
extrinsic evidence or types of extrinsic evidence that I guess was used was uniform industry custom. Now, that is not something you're arguing anymore, is it?
We're not arguing about uniform custom and practice, Your Honor. We are arguing that the industry expectation was certainly relevant. It affected what the trustees' course of performance.
What about the Amici's brief, though? Doesn't that kind of negate that argument?
Well, no, Your Honor. I want to distinguish between two periods of time.
Okay.
U.S. Bank is talking about what its current practice is. What we're talking about, and what I think the focus of Justice Barak's opinion at trial was about the understanding and the expectation in the industry when that guidance was being enacted in 2008, 9, 10, because that shaped the trustees' course of performance. There were advocacy from senior certificate holders, including PIMCO, which is one of the appellants here, saying that they wanted these to be treated as realized losses, that they believed the definition of liquidation, to Justice Chan's point, was not defined in the PSAs. This term wasn't defined and was susceptible of an understanding that these could be treated as bifurcated effectively after they were modified. So you had a modified portion of a loan, which would have deferred principal and extinguished interest, which met the definition of
aspect that had principal in it.
Regular amortizing schedule. Yes, Your Honor, that's right. And as for the definition of liquidation, yes, it's true. Some of the PSAs incorporate the Fannie Mae Servicer Guide, but even the Servicer Guide includes in its definition of what constitutes a liquidation, things like charge-offs, which don't require full extinguishment of a loan. And for the other PSAs that don't, we revert to the general understanding of what liquidation is. And that can mean adjustment, according to Black's Law Dictionary anyway, as well as extinguishment. And that's certainly what you have with these modified loans. You have modification or adjustment of the principal balance, and you do have extinguishment, certainly, which Justice Barak pointed out, of the loan of the interest obligation on the deferred principal amount. I do just want to say a word about the course of performance here. Once assuming we agree ultimately that these PSAs are ambiguous, the trustee did for over a decade consistently treat deferred principal payments as subsequent recoveries, as counsel for the seniors noted, for a long period of time. That resulted in, I'm sorry.
That was included in the certificate holder reports.
Yes, Your
right?
Honor.
And was there any evidence in the record that the certificate holders didn't understand that?
No certificate holder testified to any confusion or misunderstanding about that. In fact, rather the reverse. There was both testimony from a trustee employee about what those documents show, and there were letters sent from certificate holders to the trustee where they reference deferred principal payments on those remittance reports and described them as subsequent recoveries and challenged our subsequent recovery practice. So exactly the opposite. To the extent there is extant evidence in the record, it was very much that the certificate holders understood what the trustee was doing and didn't object to that practice for over a decade, Your Honor. And in terms of the course of performance itself, Your Honor, there were multiple trustee witnesses who testified, including members of the trustees' payments team who interact with the PSAs and with these remittance reports regularly. There was no contrary fact evidence that was presented about the trustees' course of performance here. And unless Your Honors have other questions, I'll submit.
Thank you, counsel.
Thank you.
Your Honor, Courtney Statfeld for Respondent, the junior certificate holders. I'd like to start by saying if deferred principal doesn't fit the liquidated mortgage loan definition, it can't be a realized loss any more than it can be a subsequent recovery. And if it is a realized loss, then it is also a liquidated mortgage loan. If it can be a liquidated mortgage loan for the realized loss definition, then it can also be a liquidated mortgage loan for the subsequent recovery definition. This court has already decided that deferred principal is a realized loss, and it makes sense. In this case, context is king. 17 days of trial, 10 witnesses, tens of thousands of documents, all pointed in one direction where the credible evidence showed that deferred principal payments are subsequent recoveries.
Counsel, we haven't yet talked about interim position 55.
Sure.
And Ms. Lohmeyer's testimony about that.
So
does that contradict what you were just saying?
Absolutely not. It supports it affirmatively. So what interim position 55 did, it was a memorialization of what Wells Fargo's practices and procedures already were, which was to treat deferred principal payments as a subsequent recovery. The problem was at the time is that their modeling system known as Intex hadn't yet adapted to this new type of deferred principal.
That was a software, quote unquote, software issue.
That's correct. It was a software issue that was then corrected through interim position 55 to support the course of performance that went on for the next 10 years. So turning to what didn't exist, HAMP, right? HAMP didn't exist when these PSAs were drafted. They were drafted in 2005 to 2007. You get
That's the round hole and square peg issue at the center of this case.
Yes, but because of that, we start where the FDIC was, which is that they treated deferred principal as a realized loss. They published that you wrote down certificates. Now, these trusts have assets and liabilities. In order to balance those assets and liabilities, you need to write up certificates upon receipt of recoveries of realized losses. And that's what the FDIC said to do. Realized loss at the front end, recovery at the back end. HAMP comes out, and there's a bunch of questions. And so Treasury publishes FAQ 26. FAQ 26 says, do we follow the FDIC? Yes, we do. We treat them as realized losses on the front end and recoveries on the back end. They then get some additional questions. There's clarification. Do we still follow the FDIC? Yes, we do. Realized loss on the front end, subsequent recovery on the back end. So now the industry, they start talking about how to handle this. And there is a resolution sent by senior certificate holders of the American Securitization Forum to treat these as a partial liquidation. Partial liquidation is not a new concept. Why is this a partial liquidation? The interest is extinguished on deferred principal. It is gone. You have a settlement of a debt. It is now changed entirely. This debt is changed. It's turned into a balloon payment that was not expected to be recovered. HAMP modifications redefaulted at unprecedented rates. The industry valued this at 12 to 13 cents on the dollar. The industry understood these were partial liquidations. So when we talk about what the industry also
Just historically, what happened then? I guess there was this big settlement, right, with JP Morgan or something? In other words, where did all the money come from?
So the money ends up coming in because of COVID, actually. So what starts to happen is housing prices go up, people sell their homes, and under these agreements, these HAMP modifications, you have to pay off the HAMP modification when the loan is sold or at the end of the life of the loan, which is why it's not principal funds for what it's worth. You heard the term principal funds. Part of the definition of principal funds is a prepayment. This is not a prepayment. So there's so what happens is COVID happens, people pay these, and that's why these ultimately get paid. But at the time—
It's a peripheral issue. I'm sorry, I maybe led you down.
No problem at all. At the time when this was decided, when these discussions were happening during the financial crisis, there was no anticipation this was going to come back. And I'd like to talk about what that means. So when servicers determined these were realized losses, that determination is reported to the trustee as a loss, capital L, capital O, capital SS. It's a loss. And what does that mean? There is no expectation of recovery of these funds. Wells Fargo witnesses testified that that's how they understood it. Experts testified that when you see a realized loss, the servicer has made a determination that it has no expectation of recovery. So there's no question that the trial evidence, again, 17 days, 10 witnesses, and thousands of documents, all the credible evidence, HBK's witness who talked about liquidation was deemed not credible. All the credible evidence pointed to the same conclusion. This was a partial liquidation that fit the realized loss definition and therefore also fits the subsequent recovery definition.
Thank you.
May it please the court. I'd like to try to make 2 points, one on the liquidation point, and if I have time to talk about principal funds. The first thing I want to make clear, crystal clear, is our position. We are not saying that there was, let me put it this way, whatever ambiguity may have existed the first time around, we are now post-trial, and our argument is simply that post-trial, especially with respect to liquidation, the evidence is very one-sided. You have testimony at trial from Wells Fargo's 30B6 witness. He says forbearance is different from liquidation. You have contemporaneous evidence, that's at A619. You have contemporaneous documents from Sheridan Crossley, Wells Fargo's subject matter expert, A6845, says the same thing to an investor in response to an inquiry. In interim position 55, this is A3855, this is not just a computer glitch. They are saying they have read the documents, the PSAs, and they are specifically contrasting recoveries, small r, recoveries on active loans with subsequent recoveries on liquidated loans. That is distinguishing active with liquidated. So we think post-trial, that is why the meaning is clear. On the principal funds, what I would say is that you have to go back to the text. This is sort of not, well, what makes sense. There is a waterfall. There are definitions that are broad. They clearly apply here. The deferred principal payments are paid either when scheduled or they are paid before due. The idea that it would be absurd, we think, is just simply refuted by US Bank. Remember, US Bank has done this from the start. They have just followed the waterfall. They had said there is no liquidation. And the idea that you would write up the seniors, our understanding of the seniors, we're not really sure how they ground that in the text, to be honest. But from what we understand, they're just trying to get part of the waterfall. They want to use the excess cash flow part of the waterfall, but not the other parts, and to say, hey, we should get written up like we were in the old days. But we think we should take the entire waterfall because these are sophisticated investors. They can follow the text. They knew what was happening. They could have contracted differently.
Thank you, Councilman.
like to address a couple points, beginning with Justice O'Neill Levy's question about the remittance reports, because the answer that we got was not accurate. As a threshold matter, the remittance reports could not have revealed the subsequent recovery treatment because the testimony of Sarah Lohmeyer, which the trial court repeatedly found credible, was that it was standardized reporting, standardized across all trusts, and did not correspond to the PSA definition, not to any particular PSA, and certainly not to every PSA. It was also conceded by Wells Fargo witnesses at trial that there was just one reference to subsequent recoveries in these 100-page reports. That was an aggregated line item for gains and subsequent recoveries, realized losses, that was aggregated and, as the witnesses conceded, impossible to disaggregate. Both Mr. Brem, Mr. Akers, and Ms. Lohmeyer admitted there was no way, based on those reports alone, to determine that this was a subsequent recovery as opposed to a gain or negative realized loss. Also important, those loans were listed, the modified loans were listed as active with no liquidation date, as one loan on one line with one loan number, no reference to any purported bifurcation or partial liquidation.
Counsel, you also, both sides, argue that there are certain evidentiary issues and mistakes made. Is there anyone you want to highlight in the remaining time you have that really infected the trial?
We discuss a number of evidentiary issues. I think the most grievous is the one we've touched on before, the heavy reliance on the JP Morgan briefing and the investor letters that followed. As this court is aware, it previously held that the JPM matter did not address the questions at issue here. The statements made there were therefore entirely irrelevant and cannot be admissions as to anything. I'd like to end briefly by discussing a point raised by Ms. Statfeld. There was never a finding by Treasury or anyone else that the realized loss definition in the PSAs was satisfied. Instead, everybody, Treasury and Wells Fargo included, recognized that we were merely treating deferred principal as a realized loss to keep the trusts in balance. The only way to keep those trusts in balance and to avoid an absurd outcome is exactly the remedy the seniors seek, which is to simply do what Wells Fargo did from 2009 to 2021 without objection.
Thank you, counsel. Thank you all. SL 400 Connecticut v. CBRE. Mr. Borgo, can you hear us okay?
I can. Thank you very much, Your Honor.
Good afternoon, Your Honors. Christopher Sullivan for SL 4000, Your Honor, not 400.
Just one second, Mr. Sullivan. Mr. Borgo, can you hear Mr. Sullivan sufficiently?
I can, and thank you again, Your Honor.
Thank you. Please continue, counsel.
Thank you, Your Honor. In reversing the lower court on the first appeal, this court construed the D.C. Code as a matter of law, not the sufficiency of the pleadings, but the plain meaning of the D.C. statute. And you ruled that under the plain meaning of Section 42-1702, CBRE was a licensee that had a dual brokerage relationship, a dual contractual relationship with both plaintiffs as their property manager and Whittle School as its broker.
What follows from that is that they should have received written permission to act on behalf of both parties in the transaction, correct?
That is correct, Your Honor. Under the D.C. Code, CBRE had an obligation, and this court ruled as much in the initial appeal, to obtain written consent of both parties to the transaction before it began representing Whittle School as its broker in connection with the negotiation of the sublease that's the subject of the brokerage agreement between plaintiffs and CBRE. You remanded the case.
Wasn't the situation unusual here because your client knew that CBRE was on both sides of the transaction?
Well, Your Honor, there is no clear indication that CBRE ever made any disclosure whatsoever. Our client, the SL 4000, was aware that CBRE was representing it as property manager. And keep in mind, the only affidavit submitted below came from SL 4000. CBRE basically defaulted on the substantive issue remitted by this court. But what SL 4000 pointed out to the lower court was that in the spring of 2016, CBRE's brokerage team was preparing the Whittle School to be
But they
presented.
know they're dealing with a broker.
I'm sorry?
They know that they're dealing with a broker.
There were two different divisions of CBRE, Your Honor. There's a brokerage division and a property management division. Yes, CBRE's brokerage team brought the Whittle School to plaintiffs. That isn't the test. The property.
You did know that CBRE was dealing on both sides.
Well, CBRE's property management team had put the property out for bid to general contractors to do a massive renovation. They were running the entire show. They had architects doing plans. They had developed a comprehensive program to convert the property into a single user entity. They had almost total control over what was happening at the property. At the same time, the brokers came to SL 4000 and said, wait a second, we've got a school that will take the entire property. The broker testified at deposition, and the lower court never addressed this, that they didn't know about the property manager, and therefore they didn't disclose or get any consent. Plaintiff said, the SL 4000 team said, we assume CBRE is CBRE. We're dealing with one organization. So we're trusting CBRE to renovate our property for $200 million. We're using their architect, their plans, and at the same time, they come to us and say, we've got a tenant that will take the entire property. They don't disclose the truth about their relationship with the tenant, that they are the
just pivoting for a minute.
Yes, Your Honor, pivot away.
Hey, we agree with you, and when we void the brokerage agreement, you'd be very happy, I'm sure. But does that justify the equitable remedy of disgorgement under DC law?
I think it does, Your Honor. When you reversed on the first appeal, you left in cause of action for unjust enrichment and the first cause of action for declaratory relief. And you pointed out that under DC law, in fact, SL 4000 is entitled to recoup, potentially entitled to recoup the first part of the brokerage commission.
How do you get around the Remsen, they cite that your opponent cites the Remsen case, so how do you get around that?
We pointed out in our papers below, Your Honor, that is not dispositive in this situation. That in fact you are entitled to recover the money you paid in that circumstance. We cited to a number of cases, including a decision of this court, the name of which is escaping me at the moment. I would point out, Your Honor, that much of the papers below are addressed to trying to get this court to revisit its initial decision, to reinterpret or reconstrue the DC code. But what you held is the law of the case. It's not a decision on the sufficiency of the pleading. It's binding, not just on the Supreme Court, but on yourselves, on the next appellate court. You ruled there was a contractual relationship between plaintiffs and CBRE. CBRE admitted to the lower court and to this court on the first appeal that it was hired by plaintiffs, that it performed property management services for plaintiffs under the sub-management agreement. What happened? They hired a new lawyer after the appeal. They came up with a whole new argument, which they could have put in front of you on the first appeal and didn't, even though you had the sub-management agreement in front of you. They completely reversed themselves. They ignored the remitter of this court, completely ignored it, and then tried to argue again the decision you had already made.
That doesn't really take us to an answer of what should happen with your disgorgement request.
Well, Your Honor, in our papers, we point out that if the contract is void ab initio, then the entire payment comes back. And that is what this court, that's the issue you remitted to the lower court. Is the brokerage agreement void for CBRE's failure to comply with 42-1703, which is the written consent provision? If it's void, then the law is very clear. The entire payment must be restored.
At what point do you acknowledge that you knew that that CBRE, was on both sides essentially of this?
The testimony, Your Honor, was that no one really focused on the fact that there were two divisions of CBRE. CBRE was a monolithic entity that SL 4000 had basically given complete control of this property, which was in trouble. So it thought it was dealing with CBRE, not one division as opposed to another division. What it didn't know was that CBRE had a special relationship with the broker through its brokerage team. At the same time, the property managers are putting it out for bid.
There came a time when you learned that, right?
I'm sorry?
There came a time when you learned that.
Absolutely.
And when was that?
I don't know that the record speaks to that, Your Honor. I know that the parties got into a dispute after the brokerage agreement, which was amended several times when it became clear that the Whittle School was bankrupt. that it defaulted 9 months into a 30-year, $1 billion lease. It never had the funds, and CBRE kept extending the dates so that it could get the second installment of its brokerage commission. And at that point in time, I think our SL 4000 began to realize there were two different divisions of CBRE, the people it had entrusted the property to.
Counsel, you did unpack that point for us already. Thank you.
Thank you. I'll return on rebuttal. Thank you, Your Honor.
Please, Mr. Borgo.
Good afternoon, and may it please the court, and thank you for the virtual appearance accommodation. Directing my comments first to the question about what the appellants... Is it coming through okay?
Yeah, we can hear you fine.
Okay, thank you. What the appellants knew and when. There is testimony from the depositions of the principals, and I apologize, I don't have the site in the record handy, where they testified to knowing all along that CBRE was in both a property management services capacity as well as a brokerage capacity in representing the tenant. They then signed a letter of intent that specifically disclosed CBRE's rule while they had that knowledge.
Let's get to his central point on the disgorgement. If it's null and void, why shouldn't you have to disgorge the brokerage which you received? You have to have collected that brokerage based upon an agreement which we would now be holding as void.
We would argue, Your Honor, that the statute does not make any requirement for disgorgement, leaves the question entirely open, and under Remsen, therefore, the issue would be equitable and based on the factual circumstances of the particular case. Here, where they, in effect, consented by their actions and their knowledge to CBRE's role as sophisticated individuals who intentionally curated the relationships of the parties in the way they did, having been represented by their own broker, Cushman and Wakefield, and themselves brokers and lawyers, clearly understood what was happening and consented to CBRE bringing them the tenant they got. CBRE does not warrant that a tenant will ultimately perform under the lease, and therefore they earned that commission that they were paid.
What about the practice of getting written consent?
In
Is
what
there an
sense, Your Honor?
obligation that it has to be written consent, or can it just be a course of conduct?
Well, I think it needs to be written consent if consent is required. But as we have argued here, the statute under its plain language does not provide for this having been a brokerage relationship because there was no engagement of respondent by the landlord. We cannot ignore the express language of the code, which could have stopped on the word licensee, but went forward to say engaged by such client, which means the drafters were very clear in wanting the dual agency requiring disclosure to be predicated upon a specific contractual engagement by the landlord of the broker. It's undisputed that we do not have that here. So the statutory prerequisite for a dual agency requiring disclosure was not met here. Now, we are not unmindful of the fact that this is a consumer protection statute. But here, for the reasons we've been discussing here a moment ago, the policy behind the statute is not served here, where you had highly sophisticated brokers and lawyers who were the principals of the appellants as landlord, and who specifically did not want to have a contractual relationship with whoever the property manager they hired, which was the entity we refer to as Property Manager LLC, went out and hired to assist them in providing their services. That, to us, is the distinguishing factor in this case, Your Honors, which is that they intentionally took themselves outside the protective scope of the statute.
Of course, the other side makes the point that DC law is the same as New York law here, that a subagent appointed by an authorized agent owes the same duties to the principal. So how do you deal with that?
So several ways, Your Honor. First, that disregards the express language of the statute, because under that sub-agency theory, you do not have engaged by such client. We have to assume there was a reason that the drafters put that language in the statute and didn't leave it out. Secondly, under a sub-agency theory, it only exists when the sub-agency has assented to acting under the principal's control. And the contracts at issue in this case specifically provide that that CBRE, even if it were a subagent, is not operating under the control of the landlord. In fact, the landlord's contract with its sole and exclusive property manager, that property manager LLC entity, has full and absolute control and discretion over whoever it is they hire to assist them in providing services. So none of those subagency theories apply. And in fact, the cases that the appellant relies on are all cases in which you have an entity or an individual signing a contract on behalf of somebody else. And that's not what we have here. The appellants were very careful to curate a series of relationships that would insulate them from liability for anything that this alleged subagent would do. But now they want to reverse course and say, please disregard all of that, because it's now convenient for us to use this argument as a sword.
Mr. Bordeaux, I don't know if you can see the light, but you're out of time. Let me give you 30 more seconds, but I do have a question for you. What about our prior ruling? What about our prior ruling that your client was the licensee of the plaintiff?
So on the motion to dismiss, that was the question. The question was CBRE a licensee and therefore coming within the statute? It was at the motion to dismiss stage, at a point at which prior counsel was not focused on this question of whether the other elements of the statute had been met. And that's exactly what the case was remanded to determine, whether or not there was compliance with the code. So that issue of the ability to state a claim, taking the allegations as true in the motion to dismiss, doesn't equate to this court serving as the ultimate trier of fact before an answer was even filed. Because if we accept the appellant's argument, there was no reason for us to ever even filed an answer, and appellants didn't object to any discovery into the contractual or lack of contractual relationships with the parties, because nobody understood this court's ruling to be a final decision on the merits as to whether those portions of the act have been complied with. Thank you.
Thank you, counsel.
Very briefly, Your Honor, page 980 of the record, we note that this court, in its initial decision, cites to Attias versus Care First on the point of returning the brokerage commission that was paid. We point out that plaintiff's entitled to recover the commission if the court determines the brokerage agreement is void and unenforceable. And then at page 1020, we distinguish between Remsen and Jenkins. In Jenkins, the court ordered disgorgement and pointed out that...
But our prior decision didn't order disgorgement.
No, I understand, Your Honor.
It allowed you to go forward with that pleading, which then leads to, does it not lead to then a discretionary equitable determination?
Well, it's more than discretionary, Your Honor. The distinction between Remsen and Jenkins is injury to the plaintiff. In Jenkins, there was substantial injury and disgorgement was ordered. In Remsen, there was no injury. CBRE's action destroyed the plaintiff. The property is vacant to this day. They defaulted on their mortgage. Cost them hundreds of millions of dollars. Thank you, Your Honor.
Thank you, counsel. Thank you both. Mr. Bordeaux, safe home.
Thank you, Your Honors.
Nelly de Perez de v. Forom Valentine. Please.
Good afternoon, Your Honors. May it please the court. Larry Green with O'Toole Scrivo for the appellate defendant, Pavlak Contracting, Inc. Very simple case, much simpler than some of the others we've heard of. Basically, the plaintiff slipped.
Anytime a spinal is involved, I don't find it very simple. Keep going.
Well, I like to think I have a little complexity to my simple bodily injury case here, sir. But the plaintiff fell in December 2021. My client Pavlak was the general contractor. They had sidewalk work that commenced on July 14th of 2022, 7 months later. They also did not perform the work themselves. They subcontracted it to East End Concrete. Therefore, Valentine Associates, who retained Pavlak, has not sued us for the obvious reason that the work on the sidewalk where the plaintiff says she slipped or tripped was performed 7 months after the accident.
The main impediment I see to your argument is the DOB filing. Do you want it, because that's got photos with a plywood setup. We don't know if it's set up exactly where she fell or anything like that, but what's your argument? How do you get around the DOB filing, which was from September, a few months before the accident?
Right, and I think that's a part where the plaintiff, I mean, they're kind of grasping at straws and not understanding my argument. We did not say that Pavlik didn't do any work at the site before her accident. There's, you dig the foundation, you do the superstructure. There's a lot of work that was done at the site. But the change order 45 and the subsequent work to be done to like demolish and replace the pedestrian sidewalk was done in July. And we have photographs and photos, which are part of the contract documents, showing when that commenced. And the plaintiff has indicated, and she had indicated before we made our motion, that she tripped on the sidewalk. And then subsequently, first we filed one motion, and then this case got consolidated to another case, and we were directed to refile it. And the plaintiff has served this discovery, and she showed photos with these grid lines. I think it's at 102 of the record, which there's no sidewalk shed. She doesn't allege in her bill of particulars that she served for our motion that she tripped because of a sidewalk shed. It has nothing to do. The fact that there may have been a sidewalk shed blocking part of the sidewalk has zero to do with the defect that she claimed she tripped on.
No, it's more the inference that work was being done on the sidewalk, which I know you don't agree with, but
right.
The change order was from July of 21, right? So that was before the accident.
So it was agreed that the work would take
right.
place.
You say it wasn't operated upon. It wasn't implemented.
And this
Correct.
is a motion to dismiss, so at this juncture, we don't know, do we?
Well, we do, Your Honor, because we have the contract documents, right? And among the contract documents, the daily reports with photos, and it says Yadox, which are those big orange and white barrels they put in and say, you can't walk here. They were placed, and then they broke up the sidewalk like with jackhammers, and then they removed the debris, and then they poured new sidewalk flags. And that's what happened. None of that took place until July of 2022. There's nothing in the plaintiff's opposition that says that anything to do with any work that Pavlik did could have possibly caused this accident. Moreover, Pavlik didn't actually do that work, and that's the Espinal doctrine. They subcontracted that work, so they could not have launched a force or instrument of harm.
Again, what do we do about the fact that there's a violation which does precede the date of the accident, right?
Well, of course, Judge, but again, it's the same thing. It's like you have a sidewalk shed that they said, this is a violation. You're blocking part of the sidewalk. You're impeding pedestrian traffic. But the plaintiff's bill of particulars and discovery, which she served before our motion, does not say that she tripped on a sidewalk shed or anything that was caused by a sidewalk shed. There's no sidewalk shed in the photos that she submitted. There's just simply no evidence that has any connection to her tripping and falling.
But it does mean that you were doing work there at that time because DOT observed that you had a plywood fence as of September of 2021.
Right.
So
But,
if you wouldn't have had a plywood fence there unless you were doing something.
well, judges, I have to reiterate again, the owner of the property has not sued us. And the reason is it's plainly apparent. There's no evidence that any work that was done there had anything to do with these little grid lines that the plaintiff allegedly tripped on. There's just simply no evidence of that. We're saying we didn't touch the site, we didn't do work on, we did not alter the sidewalk. We may have worked in the site, which is within the sidewalk.
But at this point on the motion to dismiss, if you were doing some work as of September 2021, it seems to me that you stay in until we know what happened.
Well, Judge, I mean, at some point, we have to ask ourselves common sense. We have a contractor that did not alter the sidewalk in any way. They don't own and control the site. If the plaintiff has a theory to say that your work could have caused this defect, let them advance it in opposition to our motion. We got nothing. And so at some point, do we spend $100,000 for an innocent contractor? And again, the owner never sued us. The owner did not bother to file a response to this appeal. The plaintiff didn't even file a response until this court sent them a letter in December saying, hey, they briefed in April. Are you going to do it or not? And then they finally responded. No one cares about us. Everyone knows that we're going to get out. And yet we're being dragged along.
Not yet, counsel, but maybe you will be. Who knows after this appeal? You got time on rebuttal. Please.
Good afternoon, Your Honors. James Ford from Amrani and Town for the plaintiff.
So why should they stay in?
We have questions, and we're allowed to ask them. There's a very big question here. If you look at the original building permit that was issued by the Department of Buildings, which is on page 137 of the record, they're only doing work inside. The work is for the cellar, first and second floors, installed new egress, no change to envelope of building. So why do they have a plywood fence blocking the sidewalk 3 months before My Lady Falls? So we're entitled to questions. We don't have to accept the affidavit of the owner saying, we didn't do it. I think it's kind of odd also that there's a change order in July of 2021 to tear up the sidewalk and start working on the sidewalk. That was in addition to the original contract from 2020, because the original contract had nothing about the sidewalk being done. So July of 21, there's a change order, and then they don't start the work on tearing up the sidewalk until July 22. Maybe their records are wrong. So this was a pre-answer motion to dismiss the case. It's a 3211 motion. It's not a 3212 motion for summary judgment. So we're entitled to ask our questions of when this work was done, and whether it was done by Pavlak or by their subcontractor. They're responsible for the actions of their subcontractor. And if it turns out that the work that they did either launched or caused a force of harm, then they'd be liable under SPL.
Justice Danziger did not treat this as a motion. He didn't convert it to a motion for summary judgment. So there's still the possibility of motion for summary judgment to sort
Sure,
this out.
of course. And if it turns out that they're right, then so be it. But the motion was premature.
What about their argument that the defect, the specific defect, predates any work that they were going to do?
That's an interesting opinion. And that's what it is. It's an opinion by defense counsel looking at the photographs that it looks like it's in old condition. So
Thank you, counsel.
thank you.
So, Your Honors, I think what we heard was a classic case of a mere expression of hope that further discovery will show that there's liability. And that's essentially, it's not allowed, it's not sufficient to defeat a motion, pre-answer motion to dismiss Freeman v. Breacher, 155-83rd, 453, First Department, 2017, many other cases, similar cases. The other thing about the photo showing it's in old condition, it's not an opinion. The photo has a timestamp on it, and it says December 23rd. We're accepting their representation. That predates the work on the sidewalk.
That's the photo that's unauthenticated by the plaintiff, but since they're offering it, you're using it against them, right?
It is an admission by the plaintiff's counsel.
Okay.
And it contains.
I just want to make sure it was a plaintiff taken by a photo taken by the plaintiff, that one.
Well, yes, I mean, I don't know if they indicate.
Offered by the plaintiff.
It was offered by the plaintiff. It says it indicates what the defect is, but by the fact that it's metadata, the stamp on it, which we didn't put that there, it says December 23rd, 2021, that indicates it existed as of that date, and that's more than 7 months before we started working on the sidewalk. And again, we have questions. Is it not enough to keep an innocent party that has not done any work on the sidewalk in a case and force them to expend substantial money? Also, lastly, I would just say, we do appeal from the, I guess, there was no consideration of our motion for costs, which is our client has been forced to expend costs. The owner themselves has not sued us. Under Espinal, we cannot be liable to this plaintiff because we did not actually do the work, and they did not have any detrimental reliance, nor did we assume the entire duty of care of the owner. So there's no way for them to sue us. It would have to be the owner. That's typically how that happens. You had a premises case, construction is going on, the owner gets sued, and they sue everybody who could have caused the defect, which they did not sue us for that obvious reason. Thank you, Your Honors.
Thank you, counsel. Thank you both. People v. Soio. Please.
Good afternoon. May it please the court, Justice Moulton, honorable members of the court. My name's Eric Nelson. I represent Gino Soio, the appellant. I would like to discuss 3 issues which were raised in the brief, but I would like to expand on them in terms of my oral presentation to you.
There was a labor law case earlier today where where plaintiff's counsel said, basically, all you have to do is look at the video. Why isn't that the case here, too?
Well, Justice Gessmer, when I heard that remark, quoting Warner Wolf, I know this court, through the clerk's office, requested a video. So it was a compilation video, which was People's Exhibit number 14, that the people presented at the course of the trial. Now, I would like to discuss respectfully some of the issues, notwithstanding the video in this particular case.
Okay, but why doesn't the video essentially resolve the case?
Because it involves an interpretation of the word and the term substantial, which the trial court charged the jury. And if I could read from the charge that was given to the jury came back with a note in terms of asking what the term substantial means. Because part of the hate crime statute under the belief or perception section, which I believe is Penal Law Section 485, Subdivision B, the jury came back with a note, amongst many notes, which asked for the definition of the term substantial. After a colloquy between the attorneys, between the prosecution and the defense attorney, the court instructed the jury, quote, substantial means more than a little. And the court based its rationale on that definition on the case of People v. Chittick, which was an assault case that went to the New York Court of Appeals, reported at 8 New York 3rd. And what the Court of Appeals in that case defined, which has been defined several times by the Court of Appeals in terms of what constitutes pain, which is both an objective and a subjective test. The court in Chittick stated that substantial means more than...
Counsel, you do a very good job in your brief unpacking this, and you want us to rely, or you think that the court should have charged more along the lines of what the Fox court did and charged, correct?
Exactly, Your Honor, and I say this for the following reasons, and I present the following arguments to the court. In several different areas of the penal law, the word substantial is defined. It's defined in Penal Law Section 15.05, subdivisions 3 and 4, under what is determined as reckless conduct and criminal negligent conduct. And they talk about a substantial risk. I submit to the court that the word substantial and pain, or substantial and risk, as defined in those respective statutes, are joined together. There is no definition of the term substantial. The only court which has decided the issue of what substantial is within New York State is the case of People v. Fox, which I submit to the court should give respectful authority to that decision, for the reason it was written by Justice Conviser, who was Governor Pataki's counsel when the hate crime statute was enacted by the legislature. Secondly, Your Honors, there is a treatise which I cited as part of my reply brief, which is called The Analysis of Hate Crimes, and it's written by Zachary Wolf, published by Thomson Reuters, by Matthew Bender, and I affixed copies of that treatise, which defines the term substantial. And it's not just more than a little. And I submit, Your Honors, that was prejudicial in this case, considering the summation in this case, which is another point which I'll get to, which I submit to the court was egregious in terms of recounting the entire civil rights history of African Americans and other individuals of different national origins before, and that was a tee-off by the prosecution to get into the facts of the case. In it, he described the appellant as a white nationalist, a white Christian. Your Honor, I submit to the court, and I respectfully acknowledge to the court that that issue was not preserved at the time of the summations. However, this court in other cases has reviewed the summation when it's egregious, when there's a pattern of discrimination, when it's invidious in the interest of justice. So I respectfully call upon the court to examine the summation in the interest of justice. And by the fact that this charge was given as meaning more than a little, coupled with the summation in this particular case, I submit created prejudice, and any error was not harmless to Mr. Soio. Additionally,
Counsel, you got time in rebuttal.
I will.
The red
Thank
light
you.
is on.
Thank you, Judge.
Please.
May it please the court, Alex King for the people. The video does resolve this case. After unleashing a
Let's go back to Fox. Now, should the court have instructed the jury that substantial is considerable, or use the word considerable?
Absolutely not. So to begin with, Fox is not on point. Fox was answering a different question. There was a vagueness challenge in that case, and the court only needed to define what conduct was clearly prescribed by the statute. Even under the heightened standard that the court used in Fox, deliberately targeting gay men for robbery is, of course, clearly prescribed by the Hate Crimes Act. In the context of this case, the court's response to the jury note was appropriate. It made good sense for the court to start its analysis with a case interpreting the same word elsewhere in the penal law. Significantly, that case does not stand alone. The response properly conveyed a core principle of mixed motives case law, that for a motivation to be substantial, it must be a factor that impels the defendant to act, but it need not be a dominant or considerable factor.
You also make the argument that there's overwhelming evidence of guilt based on the video, which you started with, so that even if the standard is considerable, that was well exceeded.
Your Honor is correct. So the response to begin with was accurate, but this debate may well be academic because the evidence proved defendant's guilt beyond a reasonable doubt, even under the standard he himself proposes. There was overwhelming evidence captured on video of defendant's prescribed motive, 30 minutes of video footage, as a matter of fact, depicting defendant heaping hateful abuse on his victims. Defendant's self-serving attempt to explain away his words at trial was simply not plausible. Defendant's challenge to the summation is unpreserved, but as the court recognized below, it was directly responsive to what defense counsel had just said. The prosecutor was entitled to invoke societal changes to explain why the jury should convict this defendant, and any error, if there was an error, was harmless. If there are no further questions, we ask that you affirm.
Thank you, counsel.
Your Honor, just briefly. The videotape in this particular case presents conflicting testimony, which was recognized by the prosecution in the trial court, as to whether or not when the individual was stabbed, when the victim was stabbed by Mr. Soio, whether or not at that moment it was motivated or falls within the hate crime statute.
Yeah, that's a heavy lift, counsel. I don't know, because the video just goes on and on with the epithets and by Mr. Soio, and he may have been inebriated. He appears to be inebriated, but that doesn't matter. It's just the context. You can't just take like the 2 seconds before he sliced up Mr. Ahmed and say, this is what's important. It's the whole context, and it was lengthy. I've never seen a bias case like this.
Your Honor, I submit that the video is not pretty, and I'm not here to justify.
But I mean, you're trying to isolate, if I understand you correctly, maybe I'm wrong, but you're trying to say that around the time he's cut Mr. Ahmed, that you need to look at that in isolation? Is that what you're saying?
I'm not necessarily saying that, but I'm saying that the hate crime statute provides for an enhanced sentencing. In this particular case, Mr. Soio received 9 years in this case. he was acquitted of other hate crime statutes under the selection theory. So he was acquitted of attempted murder, attempted assault 1, and assault 2 under the
selection theory.
selection
Yeah.
theory. He was convicted of attempted assault 1 and assault 2 under the perception or belief theory. The words in the statute, substantial, I submit to the court, are key. It's not harmless for the reason that Mr. Soio is serving additional time by the fact that he was convicted of a hate crime statute that I respectfully submit, is based upon an erroneous charge. There are other sections in the penal law that talk about substantial.
What was the maximum sentence he could have gotten? I know the people had asked for 10.
And he received 9, Your Honor.
And what was the maximum he could have
Judge,
received?
I'm sorry.
What was the maximum that he could have received?
Your Honor, I don't have that information. I apologize.
Okay, it's okay.
As to what the maximum would be for that charge. So I submit to the court that even if the court affirms part of the conviction in this case, namely the attempted assault 1 and the assault 2, not as a hate crime, but just under a regular attempted assault 1 and assault 2, I submit that the judge's instruction, the court's instruction in this case, was erroneous because there are other sections that talk about substantial.
No, counsel, you've definitely,
That's not more than trivial.
you've nailed that point home in your brief and on the presentation today. Thank you.
Thank you. Thank you for the time.
Next case up is People v. Harrison. Oh, no, sorry, is Mazero v. Broadway 52nd.
Good afternoon, Your Honors. Please, the court. My name is Michael Reagan, and I represent Robert Samuels. Before I start, Your Honors, there's a case that came down recently that I made copies for. I gave counsel a copy. I'd like to give a copy to the court, if that's okay.
What is it, counsel? I'm sorry.
It's a case that has recently come down that I feel is dispositive.
You can just give us the citation.
Sure, it's Murillo versus Downtown New York City Owner, LLC. And it's 242 AD 3D 488. This is on October 9th, 2025.
What's the inside? I'm sorry.
It's 242 AD 3D 488. Came down in October.
488?
242 AD 3D 488.
Got it.
And that's a First Department case from October of 2025.
Counsel, you got to put your microphone a little closer. Thank you.
Okay, I apologize.
So Murillo, why
Okay.
is that important?
Well, it's important for two reasons. First, as we set forth in our brief, there are two theories of liability against my client, that we created this dangerous or defective condition through improper disposal or failure to pick up this cat wire, and the improper lighting. As I set forth in my brief, plaintiff cannot obtain common law negligence recovery when it's his job to remedy the very condition upon which he trips or falls. Plaintiff has argued in his opposition that that doesn't apply because although he was tasked with cleaning up debris, he wasn't actively engaged in cleaning debris when
Right,
his
he was
accident
going
occurred.
from one part of the work site to the other. He was just traveling, is what the argument is.
The Murillo case is relevant to that issue. Specifically in Murillo, it's interesting because it's a construction, it's a laborer employed by the same general contractor, in this case, J.T. Megan. And in that case, he was going around the construction site and he was pushing a dumpster or a cart that had debris, and he tripped and fell on construction debris, and plaintiff argued on appeal.
Okay, we'll have a look at that case, but let's talk about 240 sub 1. The fact that this is a staircase, which was a means to get from one place to another. He alleges inadequate lighting. Isn't that sufficient to give rise to a 240 sub 1 claim?
Well, that may, in fact, that's for your honors to determine. My position in the way that I read the case law is that this was merely a means of going from one portion of the building to another. This wasn't the only means of ingress or the only means of access. there was a freight elevator, and there was also another set of there was also another stairway.
But isn't that a question of fact as to whether it was the only practical means of movement from one floor to the other?
Well, I don't think so, Your Honor, because plaintiff was very clear in his testimony that not only was he aware that there was a freight elevator, but that he had utilized it in the performance of his work. So again, the case law seems fairly clear. I will admit that the most important on-point case is from the second department, but it's cited in my brief, and it's almost exactly factually analogous. It was a worker who was cleaning up debris. He slipped and fell on construction debris located upon a stairway, and the second department said that it's not 240 because he was merely utilizing the stairway as a means of getting from one portion of the building to another. He wasn't using the stairway in lieu of, as a functional equivalent of an enumerated safety device. But from my perspective, again, I'm a prime contractor. That's second level. My first level defense is I'm not a proper statutory agent. The fact of the matter is my client was responsible.
Just because he's a prime? I mean, of course primes can be agents, right?
Primes can be the agents under certain enumerated circumstances, but like I cited in my brief, under cases such, first of all, when you're liable under label 241.6, you're liable, we all know you're liable because there was negligent participant to or in the construction project, and you're held statutorily liable. In my case, my client can't even be held negligent because, number one, it was plaintiff's job to remediate the dangerous and defective condition. That's very clear under the contract and the deposition testimony. As a matter of fact, Jay McGuire on page 613 and 614 of the record, he's the witness produced upon behalf of R. Samuels. And he was asked whether or not R. Samuels had people on the site clean up construction debris, and he says, "Our rubbish becomes part of the main rubbish of the job that falls under the contract. They have laborers," they meaning JT Megan, "that go ahead with brooms all day long and clean rubbish." That's the same exact testimony as the plaintiff. So I can't be held liable for a condition which it was plaintiff's job to remediate. Now, with regard to the lighting, as your honors know, in Espinal versus Melville Snow Contractors, in Church versus Callahan, the Court of Appeals has made very clear that to create or to launch or create, that's a verb that requires misfeasance, not nonfeasance. As a matter of fact, this court made that determination in the Long versus Cushman Wakefield case. And the citation is 223 AD 3D 495. That's a First Department 2020 decision.
Thank you, counsel. You have time to rebuttal.
Jack Watkins, Kahanafeld for Respondent Cross Appellant, Broadway. Nothing I just heard really touched on my client directly, so I'm just going to launch into sort of my appellate presentation here. It's admittedly an odd decision below in that it gave my client common law indemnity and did not give my client contractual indemnity, which I don't think I've seen before.
Right, and the contract provides for any accident arising out of the work of
100% correct. It's arising out of without a negligence trigger of any kind anywhere in it, which differentiates itself both from the recent Court of Appeals decision, DeBrino, as well as this Murillo case, where the indemnity clause in that case, which two of you were on that bench, that did have a negligence trigger. So we think that it's completely different. Even if you accept everything my learned friend just said about how his client can't be held negligent, and I don't think you should or need to, because we argue that there's tons of evidence of their negligence. But even if you accept all of that, we should still be entitled to contractual indemnity because there's no question that this arises out of their work. And I'll go even further. The contract, the term in the contract here does not just say arising out of. It says arising out of or in any way incidental
by
to.
arising out of or in any way incidental to or in connection with.
Yeah, it's
Good
as
language.
broad as we possibly could make it. And there's no question that they're the only people working with this wire on the job site. There's no question they're working at that exact location on the day of the accident. It's their own witness, Mr. LaFaso, who says that the yellow rope that's visible on the Cat 6 wiring is evidence that it was wiring that was installed that day by them using that wire pull. It's their own other witness, Mr. McGuire, who says nobody else was using that kind of yellow rope or wire pull on the job site. And it's plaintiff himself who says when he came up the stairs 10, 20 minutes, 15 minutes earlier, there was no debris on the stairs. So the idea that this Cat 6 wiring with the telltale yellow rope on it showing that it was pulled through materialized or is not attributable.
RBS is there in two capacities, right? They're working for Broadway or for your general contractor, and they're also doing their own electrical work for the tenant, right?
I think that is right as to why they're on the job site, but I think on that specific location between floors 26 and 27, the JT Megan worksheets that are in the record that we point to show that they were doing work on the Broadway project in that location. So it could be that it has something to do with some of their work somewhere else on the site, potentially, but it's speculative to say that. All of the evidence is indicative of it being part and parcel of this job. And again, we feel like we more than carried our prima facie burden to show that, and that there's no contrary evidence whatsoever. If I can address one other aspect of the Murillo case, which again, I just sort of learned about, I saw that case cites to the Agard case. Agard was my case, and I can assure you that what that means is that it's about a case where someone tenders a construction site and says, hey, we're done here, please clean up our debris, because that's what the Agard case was about. It was about the carpet contractor and the smart floor contractor saying, hey, we're done here, we're signing off on our work, we're leaving. And then when they're later proved to be a defect, someone saying, well, you must have done a bad job. And they said, no, our work was inspected, signed off, and we walked away. So similarly here, in the Murillo case, you have a plaintiff who testified 17 different times it was his job to clean up debris on a particular floor, tripping on debris on that particular floor, and then trying to sue the tile contractor who might have been involved with leaving that debris out. But the fact that it cites to Agard indicates the tile contractor was gone. That's not our case here. Here, they're still working on the job site. And I don't think the fact that someone else is the debris removal contractor or has a broom is a license to leave dangerous wiring lying around on a staircase when the lights are off, where it's clearly obvious someone can trip on it. That is a classic Espinal launching a force or instrument of harm if I've ever heard one. So that's clearly a separate act of negligence. You can't just rely on the fact recklessly that, hey, it's someone else's job to sweep it up. I don't think so. Finally, I'll just say one more thing because I have a bit more time.
30 seconds.
In our papers, we pointed out that below, RBS did not argue we were negligent. They have made that argument for the first time on appeal. We really think that that's a critical point. They have some points about preservation in general that might be correct as to the issue of their negligence, but they did not argue we were negligent. Every argument they make about that is for the first time on appeal. We prevailed on that argument below. We were granted summary judgment. Plaintiff did not appeal on that basis.
Okay, thank you, counsel.
Thank you.
Good afternoon. May it please the court. Michael Casella, represent the plaintiff's respondents. I don't have much to add because counsel's already touched on some of the main issues here. But as far as the liability for Robert Samuels, in order for Robert Samuels to get out of this case, there's multiple hurdles they'd have to show to this court. Keep in mind, the court simply found questions of fact as to basically everything and said, let a jury decide these issues. Found questions of fact as to whether or not it's a labor law defendant, questions of fact as to whether or not my client was tasked with cleaning up this wire. What's important as far as that claim, and counsel sort of touched on this, Robert Samuels not only, number one, created the condition because it's the wire there that's on the staircase, but to add to that, my client tripped and fell because he wasn't cleaning at the time, and he couldn't be cleaning the stairs at the time because he couldn't see. And who was responsible for the lighting? Also Robert Samuels. So they have to show my client was cleaning at the time or knew about this cable. He didn't. There's questions of fact as to 200 negligence. As far as a 240 open paren 1, I think the closest analogy is this court's decision on a case Tolk, which admittedly was a 241-6 case, But under the statute of the industrial code, which is 1.7D1, that does require a showing that it was the sole means of access. And this court very intelligently said, well, there was a staircase my client was on in Tolk. There was also a freight elevator, just like this situation. And the court providently found a question of fact because workers don't use freight elevators.
Right, your client said as much, didn't he?
My client, in this case, said exactly the same, correct. So question of fact as to that. And lastly, as to 241.6, question of fact as to 1.71, 1.30. I think the DiMaria case, which I also handled over a decade ago at this point, and also the Bacova case, BACOVA, are on point, show why there's questions of fact. The lower court relied upon those cases, found questions of fact. The court should affirm. Any questions? All right.
Counsel, would you explain your theory as to why you should prevail on a 240 subdivision 1 claim?
Well, I mean, the court just found a question of fact. The jury would have to decide whether or not it was a sole means. I simply say there's enough evidence to raise a question of fact as to the stairwell that my client was on at the time of the accident, which had a dangerous condition on it. So essentially, there's a question of fact.
Was it a dangerous, are you saying that the dangerous condition was the wire or the lack of illumination, or was there something inherently wrong with the staircase?
No, it's both, Your Honor. There's nothing, it's not like the stairs move, like I know obviously cases where a ladder moves or a scaffold moves or collapses.
Right.
There's an issue as if the staircase is the elevation-related device, was that elevation-related device dangerous? I think this court is...
And what's the closest case
Go ahead.
in from our court that would support a 241 claim as to a staircase which is otherwise fine, but it's not well enough illuminated and there's some stuff on it that someone could trip on?
I don't know. I mean, there are cases, for example, where a staircase there's a dangerous condition on the elevation-related device, such as water on a ladder, that could create an issue as to whether or not that device is an inadequate device. But in this case, Your Honor, the court never got to the issue as to whether or not 240 open friend 1 per se was violated. The only issue that was addressed was whether or not it was a sole means, and therefore my client would have to prove to the jury that there was an actual violation. So it's not as if summary judgment was granted on 240.
If it was the sole means, there was nothing wrong with the staircase. The problem is that there wasn't good enough lighting, which is a 241.6 problem, or there was debris on it, which is also a 241.6. Do you have a case from our court where a permanently affixed staircase, which is not being used, which is not being worked on, becomes the basis of a 241 liability?
I don't specifically, and like I said, that issue really wasn't addressed.
I mean, I know there are cases in which we have held that the staircase does give rise to 241 liability, but those are cases in which there's something wrong with the staircase.
I understand, Your Honor. First of all, that issue wasn't addressed below, but secondly, there are certainly cases where the elevation-related device, such as a ladder, even without moving...
This is not a ladder. This is a permanently affixed staircase. The safety device is the staircase, which has nothing wrong with it. What it has wrong with it is the fact that there's been a violation of 241.6 possibly, or maybe there's been common law negligence in that someone left debris on it. But the safety device that we have in front of us is exactly what would be called for, this permanently affixed staircase.
I understand that, as I said, it wasn't addressed below, but there are certainly cases out there. I don't have it in my brief because it wasn't part of the legal arguments. There are certainly cases where ladders have debris. I believe there's a case where there's
This isn't a ladder.
No, but
do you have a case with a permanently affixed staircase?
No, but my position is if the staircase is a sole means, then it's analogous to an elevation-related device. And therefore, it would be treated like a ladder, Your Honor. If the stairs are the sole means, it becomes the elevation-related device. And something on an elevation-related device, such as oil or dust that causes the plaintiff to slip and fall, would be a 240 violation, or at least a question of fact.
Thank you,
Counsel. Thank you.
I'll be brief, Your Honor. Counsel mentioned that in the Murillo case, it appeared as though the contractor wasn't on site and had left the job site. And I'll just refer the court to the language. Although the allegedly hazardous tile was arguably left by ERATH after it finished its tile work and stonework on the second floor that day. So no, Your Honor, it's really quite factually analogous. That was a contractor that had created debris as a result of its work, but it didn't clean it up. And
Justice Friedman and I were on Murillo, and that seems to me very different because there the plaintiff was injured by the thing he was supposed to be fixing, whereas here, the plaintiff was not supposed to be cleaning the stairs or illuminating the stairs.
Well, Your Honor, my understanding of Murillo was that it was the plaintiff's job to clean up construction debris, and he was pushing a cart, cleaning up construction debris, and his accident happened. And then plaintiff argued.
At this time, he wasn't cleaning. When the accident happened, he wasn't cleaning. He was
He
going
was in the
from one
process of
floor to
going
another.
one floor to the next, but when he was asked if he had seen debris on the stairway, would he have picked it up? And he said, of course, that's my job. I clean up the construction debris. So the fact that it was on the stairs is really, I mean, it's unfortunate, but it's really incidental. His job was to clean up construction debris wherever it was encountered.
But he couldn't see it because there was no illumination.
Well, that's a separate issue with regard to the, Your Honor, I'm trying to address this logically, one thing at a time. I'm compartmentalizing. There's liability alleged on my client's part for the lighting. Of course, we don't know what happened to the lighting. The lighting could have gone out 2 seconds before. That's a question of fact. I understand that. But again, under the Court of Appeals decisions in Espinal and Callahan, you can't be held liable for malfeasance. It's only when you can't be held liable for failing to become an instrument of good in the language of the Eves Books case. And I know my time is out. I just need to, and I've been trying to address counsel's argument with the indemnity issue. Now, again,
30 seconds, counsel.
all I know is that it's the same contractor, J.T. Megan, and it says in the decision that it says that it was part of J.T. Megan's contractual duties to dispose of the debris, and therefore it didn't arise out of the contractor's work. That's really exactly the same situation we have in this case, at least sufficient to create a question of fact.
Thank you, counsel.
Thank you.
Very briefly, I don't represent J.T. Megan. Maybe if J.T. Megan were seeking to enforce a contractual indemnity claim against RBS, then there would be an issue as who was responsible to clean that up. But that's not where we are. I represent Broadway. We're an absentee owner. We're not on the job site. We have no responsibilities to clean this up, but it does arise out of or have a connection to or is incidental to RBS's work. That's the thrust of our argument. If there are no other questions for me, I just want to briefly address, if it's okay, the Burlington issue raised in my brief. When we raised the Burlington issue about what arising out of means in a construction indemnity clause versus what arising out of means in an insurance contract, the DeBrino case that remarked on that difference had not yet been handed down, obviously. I would now say that just as the Court of Appeals only observed that the difference between those two is that in one case you read against indemnity, and in the other case you read in favor of indemnity because that's the quintessence of insurance, but didn't otherwise tease out that distinction. I don't think you need to tease out that distinction on these facts either. I think that right now all that matters is it must at least encompass the concept of being incidental to or having a connection with the work, because we also use that language in our indemnity clause. And I think that that's as far as you need to get.
Thank you, counsel.
Thank you.
Thank you all. Khan v. Khan.
Good afternoon.
3 minutes to tell us whatever you wish to.
Okay. May it please the court, my name is Elsa Cruz Pearson. I represent the plaintiff appellant in this matrimonial appeal, Mrs. Nadine Khan. The underlying divorce commenced in May of 2021. Your Honors, this case is about an oversight in the equitable distribution analysis conducted by the Bronx County Supreme Court in Mrs. Khan's divorce. Briefly, some facts. Parties were married in 1993, and in 2018, they jointly purchased a timeshare in New Jersey.
Right, in Atlantic City, and you're saying the court neglected to include that.
I think they just made a mistake, Your Honor. I think they left it out. Based on other errors that were included in the decision, it seems like they overlooked this. They did identify it as, they identified the marriage as an economic partnership. They identified the timeshare as subject to equitable distribution. They received a lot of testimony and evidence and certified records and so forth regarding the timeshare. Both parties testified about it. And then they just failed to make a disposition, which is unfortunate. It prejudices my client and also just stalls the entire divorce. So since 2024, right? Yeah, December 31st, 2024 is when this judge who retired that same day entered this decision. Nothing has been able to move. We asked this court to address the issue. At this point, so the jurist who signed the decision and heard the trial, which was a 3-year trial, about eight dates, retired. So the new jurist who replaced her and took over her caseload declined to hear this argument, which could have just been resolved very much quicker in about February of last year. And so they have no experience with this case either. At this point, I believe that you guys have more familiarity with this case than the Supreme Court does. So we're just asking for a disposition for the timeshare so we can move on with this divorce.
I know you do ask us to go ahead and reach the issue, but just know that it's possible that if we agree with you, that we may remand it to the trial court to develop a record because we don't have all the facts in front of us, maybe.
I think you do have all the facts. So one of the benefits...
I know you make the argument.
Excuse me?
I know that you do make the argument that we have all the necessary facts in front of us.
Yeah. One of the benefits of having an absent defendant in this case is that we had to submit everything to you. So it's like thousands of pages, the entire record, all the transcripts, everything. You've got to hear. That court has not been privy to any of these conversations. They don't know the record. And in terms of efficiency, in terms of getting this done, I believe that this court would be more efficient in this matter. Furthermore, I mean, the basis is just an adequate basis for intelligent review, right? This is Tarpinian, also repeated in Reyna, and I believe that this court does have an adequate basis for an intelligent review. It's quite small, like this is a $6,000 timeshare that's holding up the entire divorce for 5 years now.
Thank you very much.
You're welcome.
Thank you very much.
Okay, have a great day.
Have a great day. Finally, People v. Adalmir Oliva. Please.
Good afternoon. The Legal Aid Society by Mimi Lee, appearing on behalf of the appellant Adalmir Oliva, who is present in the courtroom today. Around 10:30 p.m. in late January, the police stopped a cab driving in the Bronx in which Mr. Oliva was the passenger in. There are two issues in this case. I'm going to address the frisk. Even fully crediting the testimony from the police at the suppression hearing, ignoring that it should be viewed as untrustworthy as this case also had a video that contradicted the police's testimony, the police did not have reasonable suspicion for a level 3 frisk. Sergeant Octrova claimed that he feared for his safety because Mr. Oliva was wearing a bulky, large winter jacket. Again, this was late January. Octrova also claimed that he feared for his safety because Mr. Oliva was generally nervous when his cab got pulled over by the police late at night. However, the fact that he was abruptly turning in the beginning when Octrova was approaching the cab is not sufficient to justify a level 3 frisk in this case.
Should we credit the officer's testimony because he had experience with livery drivers who sometimes would commit minor traffic infractions to get the attention of the police?
So, Your Honor, Sergeant Octrova and his unit were in an unmarked car. They were in plain clothes. It's highly unreasonable that a cab driver would just be committing traffic infractions on the hopes that there might be a cop nearby. The fact that it was in an area that Octrova alleged to be high crime also, and that livery cabs sometimes commit these infractions, is not enough to escape the fact that they did not have probable cause to actually pull over the car to do the stop to begin with. That is something I can address a little later if you would like me to continue with the frisk. The testimony is not enough, which Mr. Oliva put his hands in and out of his jacket twice. That is equally consistent with non-criminal behavior. He followed the instructions when the officer told him to remove his hands from his jacket, and there was no testimony specifically that there was any type of defined outline of a weapon. Octova didn't even testify that Mr. Oliva had a bulge. He only testified that the jacket was bulky. And Mr. Oliva was sitting down in a cab. It is not unusual that a jacket might bunch up when you're sitting down. And the fact that it was bulky could mean a number of things, such as having gloves in there or having.
He did it at least he did it 2 times, I think, is the testimony, right? So the repetition, does that give rise to reasonable suspicion?
Not without all of the testimony combined. When there is no specific testimony of any.
It needed to be more
suspicion of it.
detailed, basically,
Yes.
is what you're saying.
So there's no reasonable suspicion that he could be concealing a weapon based on these observations. And with regards to the stop, the testimony that the officers gave that the car was driving in the middle of the road is explicitly contradicted by the state's own evidence. It clearly shows that the car is driving on the right side of the road. And although the prosecution argues that the car had previously been driving in the middle.
Right, and you got testimony to that effect. Why isn't that sufficient?
So the testimony is not credible in that the original sighting was of an unidentifiable car. October wasn't able to see the license plate or even the make or model. It was 2 avenues away during nighttime.
They saw the high beams, though, right?
The high beams were seen at a later point when there was a break, when the officer had turned away to a perpendicular street to look at a different group of people because he thought criminality was afoot on that perpendicular street. So it was when the officer was backing up and he was reversing in a one-way, that he saw what he thought was the car again driving in the middle of the street, and he said he saw the high beams. But it was also at that point that the officer realized it was a livery cab. It was at that point, even though the officer said that the high beams affected his vision, he was somehow able to read the license plate partially. He was able to see that the T and the C in the license plate meant that it was a livery cab. And I do see that my light is up. I will just say that the photo that was submitted showing the officer's vantage point shows that you can barely see 1 avenue away, much less 2 during the daytime. I can save the rest for rebuttal.
Thank you, counsel.
May it please the court, Oliver Lee for the people. Good afternoon, everyone. Your Honors, defendant's suppression claim is barred by his valid waiver of the right to appeal. To the extent that there was any ambiguity in the colloquy, it was cured by later language in the model colloquy, as well as the detailed written waiver.
The court failed to recite those, no words are supposed to be talismanic under Thomas, but the court in its colloquy did not mention separate and apart from trial rights. Is that fatal? Or you're saying it's cured by the written waiver, which does have the separate and apart language, correct?
Yes, Your Honor. I don't believe that the court said the separate and apart language, but that being said, it did not conflate the trial rights forfeited by his guilty plea with the waiver because it separately explained them. Additionally, it also told defendant that his waiver was a condition of the plea, which sufficiently separates those 2 concepts. And as to the scope of the waiver, the portion that my adversary points to in her brief, that happens very early on in the colloquy. The court later engages in the model colloquy, effectively curing that language. Additionally, counsel and defendant both state that they reviewed it before the defendant signed. So based on consultation with counsel, that would have also cured any defect. However, even if this court does turn to the merits of this case, there's no basis to overturn the suppression court's credibility finding. And of course, the suppression court's credibility findings are given great deference on appeal. Both officers testified that they saw the traffic infractions and their testimony was substantially corroborated by the video evidence. So turning to the first infraction, officers testified that 2 blocks away, they saw a car driving in the middle of the road. And so the surveillance video corroborated the circumstances of their description and that it showed that the streets were very well lit and it also showed that there was no traffic that would necessarily block their view. Now, what my adversary says is that the video contradicts their claim, but that's a complete misrepresentation of their testimony. What they say is they saw the cab drive in the middle of the street towards the intersection of 194th and Marion, but the actual camera view isn't of that intersection. It's specifically of the intersection of 194th and Briggs Street. So the manner in which my adversary is saying that it contradicts is not possible by the camera view. Turning to the second traffic infraction, so the officers state that they saw the same car approaching with its high beams on. Officer Ostrova testifies that the lights affected his ability to see and drive. We see on the surveillance video that the high beams are activated when the car enters the intersection, and then Officer Ostrova had to slow his vehicle down and stop as the car approached his.
What about one of the other officers, Mestra, I think, did not mention high beams. Does that matter?
He didn't mention it in his paper, or she didn't mention it in her paperwork. An omission is not the same thing as a contradiction, Your Honor, especially given the great deference that we give to suppression court credibility findings. No, it does not in this case. Additionally, Your Honors, I would also ask this court to affirm the lawfulness of Ostrova's post-stop conduct. So Ostrova had a reasonable suspicion to believe that defendant was armed. Now, contrary to what my adversary says, that the defendant simply put his hands in his jacket, what Ostrova specifically describes is he puts his hands underneath his jacket to touch his front waistband, and he does that twice. Additionally, the second time occurred right after Officer Ostrova told him to display his hands. Furthermore, he also observed the defendant acting erratically, avoiding eye contact, looking around. He also knew from his background knowledge that weapons are traditionally held in the front waistband, and from seeing that the cab had a license plate indicating that it was a cab, that cab drivers habitually will commit traffic infractions in the hopes of getting pulled over. Additionally, Your Honors—
They do that even when there's, I can see they're doing that when there's a marked police car, but when there's an unmarked police car, is it still as common to do that?
So based on the testimony, the high beams were actually activated even from 2 blocks away. So it seems like the cab driver was committing a traffic infraction the entire time in the hopes of an officer was there. I would also say that there is a siren in the back towards the intersection where the unmarked car is. So it's possible that he is committing a traffic infraction in the hopes that this is an undercover officer. We don't know for sure. Additionally, Your Honors, I would also just address the LaFontaine point that to the extent that my adversary says this court should not affirm solely for the marijuana, that is correct. Marijuana, though, can be considered in regards to the analysis for reasonable suspicion.
Right.
Thank you, Your Honors.
To address the fact that the prosecution is arguing that Ostrova made any testimony that Mr. Oliva reached for his waistband, that was never in the testimony. The testimony was that Mr. Oliva touched beneath the bulk of his jacket. So, second, in relation to the stop, the officers allegedly viewed the initial car sighting 2 avenues away, not blocks. And although the lighting looks okay on the video of the stop, we don't know what the lighting looks like 2 avenues away. And the fact that the prosecution is alleging that the high beams were on the whole way, that does not make out the infraction of the VTL, where Officer Ostrova's vision had to be affected by the use of the high beams. And as
probably talk about the appeal waiver.
Yes, so addressing the appeal waiver, the court gives so much conflicting information that the written waiver does not cure the fact that it later provides a more expansive colloquy, does not cure the beginning statement implying a absolute bar to an appeal. The model colloquy specifically indicates that judges, when applicable, should explain to defendants that they are giving up claims of errors in denials of suppression hearings. Unlike other plea cases, there was actually a suppression hearing in this case. That is the whole substance of this appeal. The trial court did not explain that to Mr. Oliva. The trial court only explained and gave an example that he would be waiving an excessive sentence claim. And for somebody that was 21 years old at the time, a layperson, somebody with very limited experience in the criminal legal system, this was his first felony conviction, the appeal waiver should not be deemed to have validly waived his right to an appeal and is unenforceable in this case. The court should still reach the merits, and the gun should have been suppressed either as a fruit of the illegal stop or alternatively as illegal frisk, and this court should reverse Mr. Oliva's conviction, grant suppression, and dismiss the indictment.
Thank you, counsel.
Thank you.
Thank you both.
I want you to fall on this.